I'd like to call this meeting to order, September 4th. Madam Administrator, would you call roll?
On the call of the roll, Member Nee.
Here.
Nee present. Member Washburn.
Just absent.
Washburn absent. Member Pelpel.
Present.
Pelpel present. Member Sims.
He's
Sims absent.
late.
Member David. David absent. Member Highland. Highland present. Member Oka.
Present.
Oka present. Vice Chair Fisher.
Present.
Fisher present. Chair Grant.
Present.
Grant present. On agenda changes, I believe that item number 6, both parties have agreed to continue the item to a future date.
Okay, so we do have a quorum.
Yes.
Okay, thank you. Okay. I'm sorry, can you repeat that again?
Concerning agenda changes, I believe that item number 6, file number 12059, both parties have agreed to continue this to a future date.
That's correct. Okay, thank you. Member Sims is going to be late, and in order to have as many members present, just as a suggestion, maybe we could move the election later down in the agenda so that everyone can be present. He should be here in about 10 minutes, 10 or 15 minutes. If not, we can move forward with that. Otherwise, I want to just make sure people are here. I see people here to make sure everyone is here for their cases to be heard, files to be heard. I see Mr. Grossman and I see Mr. St. Croix. Is Mr. Mayanki here? I can't. Oh, there you are. Okay. And is a representative from the Rec and Park Department here? No? I can't see. Okay. We'll leave that to a little bit. And is, for item number 7, is Mr. Fonda, thank you. Okay. And is someone here from the Assessor Department?
Yes, here.
Okay, thank you. I see the Clark brothers, and is a representative from the City Attorney's Office here?
Present.
Okay, got it. And last, Mr. Petrellis? Is there a rep here? Mr. Petrellis here? Okay. And a representative from the DA? Okay, thank you. Okay.
Madam Chair?
Yes.
I'd like to ask Mr. 3, even though both parties have, in item number 6 have agreed to a continuance, would that still require a motion by the task force?
Through the chair, yes, Member Yee, all continuances of items on the agenda require a motion.
You want to say move? Okay. And I move to continue item number 6, file number 12059, to the task force's next meeting.
Second.
It's been moved and seconded. Is there any public comment on continuing item number 6 to our next meeting? If not, I'd like to open it up to the task force members for discussion.
Just one clarification. Could we amend the title so that it's SEIU Local 1021? It's not 1022.
Okay,
Thanks very much.
great. Madam Administrator, you heard that? Okay. And to my item about moving the election.
Vote on.
Oh, I'm sorry.
We have discussion on that first.
We did, yeah, we did it. Oh, okay. We need to vote on the motion to continue. Madam Administrator, or Mr. Administrator, can you take a roll call vote, please?
On the motion to continue item number 6 to the next available Sunshine Ordinance Task Force meeting, Member Nee?
Aye.
Nee, aye. Member Washburn? Washburn absent. Member Pelpel?
Aye.
Pelpel, aye. Member Sims? Sims absent. Member David? David absent. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
Aye.
Fisher, aye. Chair Grant?
Aye.
Grant, aye. The motion passes.
Thank you. If we can go back to item number 2 regarding the election of the chair and vice chair, I'd like to open it up, is there any motion? I don't I have to have a discussion about this? Attorney 3? Or can I?
Madam Chair, if your intention is to continue the item until later in the meeting, then you would need to have a motion to take it out of order.
Exactly. Do we have a motion to take it out of order, the election?
I think if you just want to announce that we're just going to pass that and come back to it, I think we can do that without objection.
Attorney Glade? Okay.
Can we discuss that before you do that? It just seems that, in the hopes of having as many task force members present, why not, if we can, with 6 people, take care of that item, we should, and allow item 3 to have at least one more task force member to vote on it. I think that'd be better service to the public. Rather than, because
So are you suggesting?
I'm suggesting just keep it as it is.
Just leave it as it is?
It is, because Mr. Grossman's going to have 6 people vote for him to win his case, 6 out of 6. If there's one more person, at least it's a little bit, in the interest of justice, I think. It'd be nice if we had 11, but we don't. But if we take care of that, then by that time, maybe Member Sims will be here. That's my thought.
I'd like to open it up because it's not going to be passed for objection.
We're on item 2 now?
Yes, still on item number 2 in response to Member Highland. Sorry, I'm tired.
So are we on item 2 now?
We're on item number 2. So Member Highland had suggested that we keep the agenda as is, do the elections now versus doing it when Member Sims is here, who's emailed me, and then keeping it as is so that item number 3, we would have more members here to talk about file number 12056.
So are you now taking nominations? Is that what we're doing now?
Yeah, I wanted to open it up to see if we were in agreement to but I want to make sure that we're addressing this. Okay, so you guys want to keep it as is? Okay. Mr. Administrator, can you read the next item, please?
Comment?
There is no public comment on this item yet, just to hold nominations, because there was no motion. So we just kind of decided to keep the agenda as is. We didn't make any
I'd like
change.
to make a suggestion that you do it another way, because I think either way you're choosing to do it is inappropriate.
But
Madam Chair, with all due respect to the speaker, he was not recognized.
Yeah.
And I would suggest that until such time as that occurs, we conduct our business as per usual.
I agreed. Mr. Administrator, can you continue with the meeting?
Item number 2, election of chair and vice chair, elections of officer per Article 2, Section 3 of the bylaws.
Can you read that? So.
The officers shall be elected at the first regular meeting of the task force held on or before July 1st of each year, or at a subsequent meeting, the date of which shall be fixed by the task force at the first regular meeting on or after July 1st of each year. If any task force office becomes vacant, the office shall be filled at the first meeting after the vacancy occurs.
Great. So at this time, then, we will take nominations because I am the chair right now. I'm going to pass this.
Excuse me, Madam Chair. The proper procedure, I believe, is to have the clerk conduct the election.
Attorney Threet?
Through the chair, that is a method that is available to the task force. When you have a sitting chair and vice chair, however, another method available to the task force is to hold the elections sequentially. And when one office is being filled through an election, the other chair or vice chair can serve to chair the meeting while that's happening.
Great, thank you. So what I was going to do is turn it over to Vice Chair Fisher to conduct this portion, and then
Okay.
whoever's named chair.
Do I have a motion?
No, that's, you're
taking note.
you're the chair now.
Well, it's already been, do I have to read this again?
No, so you're
No,
taking
just-
nominations.
Oh, do I have any nominations? I'll go in order, David and then Richard. Member Pilpel, Member Nee.
All four of us. I would so nominate Chair Grant to be reelected.
Second.
Discussion?
Madam Chair,
Interim Chair?
respectfully, I suggest you ask if there are other nominations.
Do we have any other nominations?
None here.
Hearing none, do I have any discussion?
Yes.
Public comment first?
Yes.
Do I have any public comment? Hearing none? No.
No.
Fat chance.
It's a Rosh Hashanah joke.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. The reason I wanted to comment on this was I was going to suggest that you do the minutes at the end of the meeting and continue to do the minutes sequentially until you had sufficient members here. I think holding an election with half of your members missing is really inappropriate, and it really does deny them the ability to have their input and to be candidates. There may be people who are not here who are legitimate members of this board who would like to put themselves up or someone else as a candidate. As Mr. Highland mentioned, it is also inappropriate to have hearings on cases where every person who comes before you has to have a unanimous vote to prevail. I think that is the biggest miscarriage of justice that you can possibly do, and it is a total disservice to the Sunshine Ordinance and its intent. It is not open government. It is simply saying, you have to run the board to win your case. And it puts the burden, the burden is already on the complainant. It puts the burden totally on the complainant with no exception. Now, as far as this nomination goes, I have some real concerns about the chair. Number one, if you look on your own website, orders of determination for this year, there are 2 posted. These things drag out for months. I have to send in IDRs to get a thing. I sent an IDR for a letter that was supposed to be done 2 months ago, and it's still not done from EOT. These things are not being handled in accordance, and people are being denied their due process rights. The ordinance says you have 45 days to do the hearings, and you can sit and moan and groan about the fact that you don't have this or that or whatever. It doesn't change the fact that you're violating the law. The second thing is I have seen absolutely no effort to fill the vacant seats on this board and to get those people whose terms have expired replaced. If that's leadership, I don't recognize it. I spent 12 years in the United States Navy, and if anybody was a leader in a leadership position and had all of these different things going on that they couldn't control, they would not be reelected. And I have a funny feeling that what's happening here is she's being reelected because she's the only one willing to do the work. Very frankly, if people aren't willing to come to these meetings, you need to take the appropriate action. It's in your bylaws that you're supposed to keep track. It's the mayor's policy you're supposed to keep track of attendance. And if people miss meetings, they are supposed to be removed from the board and replaced with someone who will make the meetings. When you accept these positions, you agree to attend. And if you can't attend, you are doing a disservice not only to your fellow board members, but to the citizens whose rights you are here to protect.
Thank you. Do I have any other public comment? Nope. Hearing none, then should we take a vote for the motion?
On the motion, please state if you're voting for or against the motion to
Re-elect.
To re-elect Chair Grant.
reappoint Chair Grant to the position of Chair. Member Nee?
4.
Member Nee, 4. Member Pelpel?
Aye.
Is that 4?
Yes.
Member Pelpel is for the appointment. Member Highland?
4.
Member Highland is for the appointment. Member Oka?
Actually, I am very uncomfortable with this whole thing. I think what Mr. Hunt said is 100% true. We should not be doing this without full membership of the task force here. So frankly, I'm not ready to vote on this.
Madam Chair,
Yes.
members of the task force do not have the option of not voting on matters that are before them.
I'm aware of that. But there has to be something done to correct what we're missing. We are missing key parts of our task force. And until we fix it, we're not in a position to take
Point of order, Madam Chair.
Yes.
With all due respect to my colleague, Member Oka, this is not the time for debating or discussing. The discussion has already taken place, and now we're taking a vote. If Mr. Oka wishes, he can pass for the moment, but then it would have to go back around to him for an up or down vote.
Well, all right, then I pass.
Member Sims?
Aye.
Member Sims votes for the reappointment of Chair Grant.
Yes.
Vice Chair Fisher?
4.
Vice Chair Fisher is for reappointment. Chair Grant?
Aye. For myself.
Thank you. Vice Chair, Chair Grant is for the reappointment of herself to the position of Chair. Member Oka?
Reluctantly, I'm going to vote no.
Mr. Oka is against the reappointment of Chair Oka.
Yes.
We have a vote of 6-1 for the reappointment
Chair Grant.
of Chair Grant.
Do I bang?
So the next item,
Wait, it's the same
it's same item
So now you're taking it back over.
for vice chair.
Right.
So at this time, I'd like to know if there are any nominees for vice chair for the Sunshine Ordinance Task Force. Member Nee.
Madam Chair, I'd like to nominate Vice Chair Fisher for re-election.
Do I have a second?
Second.
Are there any more nominees? I'd like to open it up for discussion to the task force members. If there is none, then I'd like to open it up for public comment. If there is no public comment, well, then I will ask Mr. Administrator to take a roll call vote for or against Member Fisher, Vice Chair Fisher for her re-election.
On motion to reappoint Vice Chair Fisher to the position of Vice Chair, Member Nee?
4.
Nee, 4. Member Pelpel?
4.
Pelpel, 4. Member Sims?
4.
Sims, 4. Member Highland?
4.
Highland, 4. Member Oka?
4.
Oka, 4. Vice Chair Fisher?
4.
Vice Chair Fisher, 4. Chair Grant?
4.
Grant, 4. We have a vote of 7-0 on the motion to reappoint Vice Chair Fisher to the position of Vice Chair.
Great, thank you. Can we continue on with the next item on the agenda?
Item number 3, file number 12056. The Compliance and Amendment Committee has referred file number 12056, Alan Grossman against Johnson Croy's Executive Director, Ethics Commission for allegedly failing to justify withholding unidentified public records as exempt under provisions of the Sunshine Ordinance.
You're there. I'd like to invite Dr.
Well, I trust this is not a do-over since we've...
I'm sorry, one moment. Yes.
Normally on these items, we have the chair of the committee or a member of the committee.
Yeah.
So could we have...
She's not here, and I wasn't at that
Member Nee
meeting.
or...
Do you remember?
Yes.
Okay. Can you
I'd
hold on
love
one
to get
second
that
just so
summary.
we can give an update? I know, give the rest of the members, I'm on that committee, so I
Thank you.
apologize.
Very briefly, the Compliance and Amendments Committee has referred this back to the task force with a recommendation that the matter be referred to both the Ethics Commission and the Board of Supervisors. The reason being that we had an order of determination in this matter, and based on what the committee heard from the parties in interest, we believe there has been non-compliance with the order of determination. That is why we are bringing this back in this matter.
Thank you. My apologies. Mr. Grossman? I'd like to give you 5 minutes to kind of update us on what's going on.
So the complaint that was filed last fall was heard finally in June. You agreed on an order. It was entered, and the order of determination, I think, is dated June 24. The meeting itself was June 5th, so we're now 1 day short of 3 months from the time that the compliance obligation began. As I said, I don't see the point of redoing everything. I was at the committee meeting. Mr. St. Croix did not attend that meeting, but one of his staff lawyers did, and simply said, as I recall, that Mr. St. Croix believes that the privileges that he was asserting did apply to this unidentified group of records, and that they need not be disclosed. In terms of the recommendation of the committee that it be sent both to the Ethics Commission and the Board of Supervisors, I do think it's appropriate that it go to the Ethics Commission for one very, very good reason. The Ethics Commission is supposedly the kind of the blazing light of ethics and transparency in the city, because it not only enforces it, it writes the regulations, and it is to be as transparent as any agency or department or office should be. So I think it's appropriate to go there and let it decide how transparent it really is. And then I think everybody will understand its position in terms of the right of public access that we now have under the California Constitution. Thank you.
Thank you very much. Is there anyone, member of the public, that wants to support Mr. Grossman or offer any new facts or evidence? If not, then I would like to invite the respondent up if he had any comments. And he too gets 5 minutes.
John St. Croix, representing the Ethics Commission. I don't have anything to add. I gave you my justification. You didn't accept it. I think the die is cast on this, and that's what's going to happen.
Got it. Thank you. Is there any member of the public that wants to offer any facts or evidence in support of Mr. St. Croix? If not, then I would like to open it up to the task force. If anyone has any questions for either the complainant or the respondent. Do you have a question? I can't see your hand. Sorry. Member Pilpel?
Question to Mr. St. Croix. I recall asking if you could come up, I recall asking at the hearing on the merits if you could characterize somehow the records that were withheld, and I believe at that time you said that you could not. I'm wondering if, since then, you've had an opportunity to review those records, and if you can cast any light on the records that are in dispute.
As we stated in our written justification, there's attorney-client privilege and work product exemptions that I stated in my written statement. Documents are dealing with our enforcement processes and regulation and don't relate directly to the Sunshine Ordinance, and therefore the exemptions are legitimate.
And do you have any count as to the number of documents or number of pages? No. Okay. Thanks.
Thank you. Are there any other members have any questions or comments for either the complainant or the respondent? If not, then I'd like to move, see if there's a motion out.
Madam Chair, I'd like to move that file number 12056 be referred to the Ethics Commission and the Board of Supervisors with recommendation that appropriate action be taken to remedy what we feel is to remedy the Sunshine Ordinance violations.
Do I have a second?
Second.
It's been moved and seconded. Is there any public comment? I'm sorry? Oh, I'm sorry, yes. I don't know if the respondent or the complainant has a rebuttal or conclusion they'd like to offer. Thank you.
Excuse me, Madam Chair. The respondent should be given the opportunity first on rebuttal. Respondent.
Remember,
I'm sorry.
he doesn't have any.
He doesn't
have anything.
Okay.
I can see him.
It's hard for me to say, I'm speechless, but it happens every 8 or 10 years. With all due respect, I don't know what's going to happen because it'll get over the ethics and they're going to have some tough decisions. But I really think it's important that it get there, particularly since we have had no idea what's in those records, what they're concerned, or which of the so-called privileges might even apply absent what's in the ordinance that would otherwise prevent them from being applied as exemptions. Thank you.
Thank you.
Madam Chair?
Member Popo?
I'm looking for a reason to support this. As people probably know, I did not support the original order, but I'm more troubled with this matter of a referral in the absence of some kind of findings or determination by the task force. I think if these referrals are going to matter, something needs to be written up to back it up, or we're just sending paper around.
So I'm going to let Member Nee address that because there are some facts that were brought up from compliance.
Great.
Well, I think the record is fairly clear on the order of determination itself.
Yeah.
Task force found that the records requested from the Ethics Commission were disclosable, and that the respondent violated Section 6721B of the Sunshine Ordinance for failure to provide the records within 10 days following receipt of the records request, and Section 6724B1 of the Sunshine Ordinance for withholding records subject to disclosure. Additionally, we found, I think there was objection among the task force to just the blanket exemption that Mr. St. Croix claimed for the documents, rather than go through each requested document and give the specific exemption, statutory exemption for each requested document. He just said, well, these are all attorney-client privilege, therefore we're not going to provide them or disclose them. That pretty much sums it up. The other thing I would point out is that we're not here to re-adjudicate this matter. That the adjudication has already taken place. There was the Compliance and Amendments Committee found non-compliance with the order of determination. Therefore, that's why we want to move this forward.
Is there any more comments?
The fact that he couldn't even tell us how many documents applied to this privilege seems to suggest that blanket use of that privilege should be reason enough, I think, to open up this Pandora's box and have them relook at it and decide what needs to be examined.
I would like to ask that we take a vote on... Did I not do public comment? I'm sorry. Is there any public comment on what has been determined?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I concur with Member Highland. It's sort of a arrogant approach to take to say, I'm not going to tell you what the documents are. I'm not going to tell you which of the exemptions actually cover these documents. I'm not even going to tell you how many types of documents there are. I'm just going to tell you that I've looked at the documents. Now, very frankly, I've worked with the government in federal, state, and local levels in more than one state. And I know that it is a very easy thing to stick a document you don't want seen in a file and call it work product or attorney-client privilege simply because it's in a file with other documents that do fall in that category. And I have a question as to whether Mr. St. Croix actually even bothered to look at any of these documents to determine whether or not they did actually qualify under the exemptions, or he's simply coming here saying there are things I don't want you to see, so I'm going to claim these exemptions. Now, I know when I come here, there are probably times when some of you think I'm disrespectful. As I've said many times, I was in the military, and there was one thing I learned: you always respected the uniform, but the respect of the individual wearing the uniform was something that they earned. And I have a great deal of respect for a number of members of this body and other boards and commissions, but there is also a lack of respect for certain other members. And I really do question having these proceedings where you have 6 or 7 people and the person has to get an 85% majority to prevail. And it's not because that's something that is fair or equitable. It is because you can't get your own members to come to the meetings. Honestly, if I'm on a board or commission and I have made the commitment to do public service, if I can't make the meetings, I will resign and let someone who can do it. But to continue to allow these things to occur, where you tell all of the complainants that come before you, you have to get 6 out of 7 votes to win, it's grossly unfair. Grossly unfair. Now, as far as the matter of respect, one of the things I've learned in dealing with a number of boards and commissions in this city is the fact that you don't respect each other. The Ethics Commission doesn't respect this body. What did they do after 2 years of coming up with a procedure for handling complaints and referrals from the task force to the Ethics Commission? They voted in every single case, not just to not to support the violations. They voted to say there wasn't a violation. They didn't look at the evidence you looked at, they didn't hear the arguments, and they simply said, thumb in your eye, we're going to say you were wrong totally, and we're just going to say there wasn't even what you said was right.
Is that the buzzer? Oh, okay. Thanks. Is there any more public comment?
I just want to say that I went to 25 Van Ness one day. The elevator was broken. I just happened to be walking down the stairs. I saw a door that said ethics. I didn't know what it was. I went in. I asked if I could speak to somebody, and I went in a room with 2 investigators. The conversation was not audio taped or videotaped, and I found out some months later by doing a public record search on my name that one of the investigators alleged that I made a comment about a gun. And that to me is very shocking. I never made such a comment, and how could they make this kind of allegation with no proof? There were 2 investigators in the room there.
Point of order, Madam Chair. With all due respect to the speaker, she is not addressing the motion before us.
I knew you were going to say that. All right, thank you.
Is there any more public comment? If not, Mr. Administrator, can you take a roll call vote, please, on the item before us?
On the motion, to refer this item to the Ethics Commission and the Board of Supervisors with a recommended action to be taken to remedy violations of the Sunshine Ordinance,
Violation.
Violation.
Yes.
Great. Can we do it?
Member Nee?
Aye.
Nee, aye. Member Pelpel?
No.
Pelpel, no. Member Sims?
Yes.
Sims, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
Aye.
Fisher, aye. Chair Grant?
Aye.
Grant, aye. We have a vote of 6-1.
Great, thank you. Thank you both. It is 10-5, so the next item, you know what, let's just do public comment. Can you call the next item, please? We'll stick in the order.
Item number 5.
4.
Can we go? It's not 5 yet.
Can I do it because it's close to 5?
Item number 4, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the Sunshine Ordinance Task Force jurisdiction, but not on today's agenda.
I know we're a bit early, but I would like to open it up for public comment on any item that is not on the agenda today. And if someone comes in after, we'll continue.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. As I have mentioned on a number of occasions before, a finding against the clerk of the board for failing to include 150-word summaries, even though her order of determination was the 6th saying that same thing. She refused to do it, and it was sent to EOT. On June 25th, that was heard before EOT, and a vote was taken 3-1 to send a letter to the clerk of the board. A public document request today indicates that that has not been done, and in fact, the letter has not even been done. So what I'm going to simply start doing is this. I have a complaint here against Ms. Calvillo for failing to include the 150-word summary in the June 11th Board of Supervisors meeting minutes. Another complaint for failing to include the 150-word summary in the June 18th minutes of the Board of Supervisors meeting, and another for the June 25th meeting. All of these have been approved by and finalized by the Board of Supervisors, and we'll just see if we can just keep going through this again and again and again. And what I'm really at this point thinking I'm going to have to do is establish a pattern of behavior so that I can take it to Superior Court and sue their ass. I'm filing another complaint against City Attorney Dennis Herrera for basically acting as counsel and advising these people that they don't have to follow your rulings. And I am filing a second complaint against him for willful failure because one of the rulings is a ruling 11071, which found him in violation for failing to do this. and he ignores it. So, I mean, I don't know how much more willful someone could get. I have, well, whether you know it or not, the Library Commission had a meeting at the end of last month, and they took up the issue of allowing access to the public audiovisual equipment. As you recognize, they made a whole bunch of specious arguments about how they couldn't do it. They'd have to spend $40,000, which is a bunch of crap. Basically, all they have to do is what they do with everybody else, is take a PowerPoint slide, and I've even included the slides here. And this complaint is against the Library Commission President, Jewel Gomez, for abridgment of public testimony. Oh, I'm sorry, they took a vote and voted to disregard your order of determination. And I have a second complaint against the San Francisco Public Library, in particular City Librarian Luis Herrera, for willful failure to follow the order. And I'll tell you, this is going before Compliance and Amendments on the 17th, and they're going to come in and start the finger pointing. Mr. Herrera is going to point at the Library Commission, said, no, it's their selection, and they're going to point at Mr. Herrera and say, no, but it's a combination. He advises, they consent, and between the two of them, they're denying public access.
Thank you. Victor? Sorry. Thanks. Is there any more public comment on items now on the agenda today?
Mine won't be as dramatic as Mr. Hart's. Do I sense that there's going to be a change in the administrator of the task force?
No, it's just, this Madam Administrator is just going on vacation for a couple weeks. So
But this gentleman is just helping her, is that it?
Yes.
To do what? You don't have to answer it, because I'm just making public comment. I do think that Mr. Pilpel's no vote is probably the most indicative of the problem of this mandatory 6-vote rule that you have. And I know that it was adopted because you were all put on the task force to change what the former members had done, to use the standard Robert's Rules majority of the quorum. But the problem really is that this whole setup is stacked against the complainant. He voted no. The empty seats are no's. So I could have, the manner that I had, I could have won 5 of the 7 votes and lost. That is not only unfair, it's undemocratic, but it's contrary to the constitutional right that I have as a member of the public, which is that I'm entitled to access. And the burden is on the respondent to prove that I'm not. And that was done 2 meetings, a meeting ago of this body and again before the Compliance Committee. So what you have is this version of a board or commission that is designed to protect the public's access when in fact it does just the opposite. So my view is it's time to revisit the issue and get it straightened out. And if you don't recognize that it's an important issue that has to be dealt with, then I think you don't belong on the task force. Thank you.
Thank you. Is there any more public comment on an item not on the agenda today?
Yeah, item's not on the agenda.
Great, thank you.
Hi, my name is Dominic Mianchi, and I just wanted to bring, I read this article on a blog, I don't know if you look at cityreport.com ever, and it talked about the Essex Commission, and there was a case before it, and there was, Sarah Ballard, they're quoting her, I don't know how accurate this is, I'll assume it is. She says, I don't retain sent emails. Now, I thought that was a blanket. She was asked several times that question. She answered it again and again, that she does not retain sent emails, period. Now, the only reason I bring this to your attention is because the Ethics Commission they didn't even flinch at that. They just go, okay, that's fine. And again, they voted in her favor. It seems like, other people have talked about the Ethics Commission. It doesn't back you up. Somehow, I don't know how that's going to be remedied, but it kind of makes the Sunshine Task Force irrelevant if nobody's going to back you up. And, you know, and in light of something that, to me, that's very blatant, and I really do feel like I want to go home tomorrow morning and sunshine her sent emails so that she tells me she doesn't have any, so that I can come here and bring a complaint. Because, I mean, that's pretty blatant to say I don't, you know, and I don't save any. That's all I wanted to say.
Great, thank you.
Now is the time where I can say what I said previously. Sometime, probably 6 or 7 months ago, I went into 25 Van Ness on another matter. The elevator was broken. I walked down the stairs. I saw a door that said ethics. Walked in. I asked if I could speak to somebody without even knowing what it was. I went in a room with 2 people, which was not videotaped or audio taped. They said they were investigators, but did not really explain to me what they investigate. They listened to me for probably about an hour on matters concerning the street artist program of the San Francisco Arts Commission. And one woman gave me her card, and I walked out. Sometime later, I did a public record search on my name, and I saw that there was a TRO out for me. This woman, Catherine Agmundo, made a declaration claiming that in this room, I made a statement about either having a gun or it would be easy to have a gun. How, if there were 2 investigators in a room, why would not both of them have come forward and made that same statement? It was not audio taped. It was not videotaped. The case never, it died for lack of service. It remained open for 3 months. But I went to 400 McAllister Street. I think the date was May 29th. I looked at the file. I showed this file to the judge, and the judge agreed. There's no evidence for this allegation. It was closed. All right, thank you.
Mm-hmm. Is there any more public comment on matters not on the agenda for today?
My goodness, my understanding is that public comment doesn't start until 5 o'clock. As I look at the clock, is 2 minutes to 5 now. Is that wrong?
It's a record for us. We actually got to it in order.
I don't understand your comment. Is it not 2 minutes to 5?
We started 10 minutes early.
Yeah, this is not part of my public comment. It doesn't matter. Please, start my clock again. Thank you very much. Yeah, I came last week, I hope you remember me, and I brought a poster of the Sunshine Bill of Rights. I prepared full-size copies for you, and I've neglected it to mention then. Of course, if I just passed them out at the meeting, they'd be garbage by the time you got them home. So if anybody wants a full-size copy, please let me know. Actually, I've got a complaint that I filed on July 2nd, and actually it's fortuitous that it's delay in coming up, because I can prepare you a little bit about how it's going to be handled. When it comes up, Mr. Pilpel will try to lead you in laughter during the comments. He's always done this before. As you know, Mr. Pilpel is a very highly respected member of the City Hall community, and he assumes that the reason is because is because he can afford to laugh at people while they're making their presentations. In fact, it's the other way around. He's highly respected because he can belittle people. There's 2 factors that this has to do with. First of all, there's very little that can't be reduced to ridiculousness if you're trying to address people that are laughing while you're talking. And number 2, of course, is that this is the strategy that the departments themselves use to make sure that there's no real accountability. If you can basically demean the people who are making the complaints, there's never going to be accountability. Now, I'm active in following the Library Commission, and the Library Commission is one of the primary practitioners of this tactic. The president of the Library Commission at the time, Steve Coulter, referred to the citizens as bullshit so many times that the word bullshit came to be referred to as Lamoda Coulter. They will tell you that you need to get a life, As a matter of fact, the Library Commission has what they call a public comment fund, so that every time you complain about something, they put $5 in a kitty. And the idea is that it's just ridiculous because anytime anybody complains, they're just raising money for the private nonprofit. The trouble is, if you allow yourself to be led down this road, there's no sunshine at all. This is the way they make sure that there's a hierarchy putting themselves on top. And that hierarchy destroys equality, destroys sunshine. And in fact, if you think that the hierarchy of ridicule is something you're going to be on the top of, it's never going to happen. In fact, if you have sunshine, you have to not let this happen. Thank you very much.
Thank you. Is there any more public comment from anyone? Okay. Not on the, for items not on the agenda today? If not, then I'd like to, Mr. Clerk, can you go to the next item on the agenda?
Public comment closed.
Public comment is closed at this time.
Thank you. Item number 5. The Complaint and Amendments Committee has referred file number 12058, Dominica Mayochi against the Rec and Parks for allegedly failing to provide records requested pertaining to berthing contracts between the City and County of San Francisco and slip holders.
Great. Thank you. Member Nee, I'd like to give you the floor to give us an update on what this is about.
Yes, again, this was a matter in which the Compliance Amendments Committee found failure on the part of the Rec and Park Department to comply with an order of determination. Rec and Park had received advice from the City Attorney's Office that redactions they had made were legal. The task force disagreed for many reasons, which I can review if necessary. But for the moment, the committee is recommending that this matter be referred to the Ethics Commission with a request for appropriate action on this matter.
And I believe that we had talked about drafting a letter to, and Member Sims, do you remember this? And Member Sims was going to lead it with, and Member Washburn was going to help him with that letter. Attorney Threet?
Madam Chair, I just wanted to also remind task force members that this matter was previously before the full task force for hearing, and it appeared at that time that there might be a majority of vote for referring the matter for further enforcement, and it was at that point that the discussion was on having sufficient findings to support a referral for willful failure, and a couple of members of the task force volunteered to come up with those before the next meeting.
And we're going to pass it to Attorney Threet, too, for some of his insight as well, for that letter. So if you want to...
Oh, to send me.
Yeah, but remember we were going to have Member Sims, and they were going to pass it to Member Attorney Threet for some of his insight. He offered his insight,
Yeah, and then I was going to say...
Yeah.
Member Pilpel drafted a referral letter, which I'm in agreement with, except some exceptions. I think some of the exceptions would be, I think at the time, the majority of members of the task force were in favor of a willful violation and willful failure to act in the Sunshine Ordinance. So I think we would need to discuss edits to this, as well as whether we still have the prerequisite number to find a willful violation. I think there is definitely numbers for, and I think there are definitely numbers that still maintain today that feel that there is a violation, but I think that we need to determine whether there's numbers that would constitute willful or non-willful.
Member Pilpel, and then we'll go and get an update from the complainant respondent.
Sure. A couple of things. I had not intended to write something up, but I was moved to do so in the past month. And as it turns out, Member Sims, you ended up not doing a thing separately. So it's good that we have a thing. And that's fine. I'm happy to change that and wherever the will of the body is. I just wanted to be clear because I didn't see anything new in the packet. Was there a notification letter that went from the task force office to the respondent? And if so, who at Rec Park was notified of the hearing tonight? Because I think that's important.
Of being here tonight?
Yes.
All of us here.
I'm just trying to clarify on the record because there was nothing.
Madam Administrator did. She told both parties to be here for the meeting today.
I'd like to know if Mr. Ginsburg was notified.
Olive Gong was notified.
Okay. Because I thought we had asked at the last meeting that Mr. Ginsburg be notified as well, because the question of a willful violation, whether it's willful or not willful, either way, I think it's important for the respondent to be personally notified and not just the person who's been attending. So I don't know if that creates a problem. Anyway, I wanted to be clear about that. In terms of the document, and we held the hearing, we were prepared to make a motion at that point. We continued the matter, so we certainly will take further public comment, but I'm not sure that we need to go through the whole.
Yeah, I'd like to I want to offer the complainant, the respondent, the opportunity to give us an update what's going on. And as a matter of fact, I'd like to hold getting into the details of this letter, and I'd like to see if there's anything new from the complainant respondent. Okay, thank you. Can I, Mr. Bianchi, like to offer you opportunity to come up and kind of give us an update if there's anything?
Absolutely no news on my side.
Okay.
Nothing's changed.
Okay.
If you have any questions or...
We'll get to that in a second. If there's anyone here that wants to offer any facts or evidence for Mr. Bianchi, if not, then I'd like to invite the respondent up. I saw her.
Good afternoon.
Good afternoon. Do you have any update or anything?
No.
I have a question for you. Was Mr. Ginsburg notified? Did you tell him that you were going to be coming, that you've been brought back here?
No.
So you did not tell him? Okay. Thank you. Is there anyone here to offer any facts or evidence or anything supporting Ms. Gong? If not, then let me open it back up now to the task force members. And knowing that Mr. Ginsburg has not been notified, which was not in the minutes, correct, Madam Administrator? Or because you were here last time.
I have to look in the minutes. You'll give me time to look in the minutes.
Oh, okay, sure. Okay. Like to open it back up to members of the task force, and we'll wait a second. But in the meantime, if you want to,
just as a matter of course, the fact that he's the head of the department and responsible for this case, he really should be aware of what's going on. I don't really see the fact that he wasn't notified.
Say it again?
I don't see the fact that he wasn't notified any real excuse that he hasn't been here from day one, really.
Yeah.
Quite honestly.
But they also, within our jurisdiction, they also have the opportunity to send a representative from their department. So I agree with you, particularly in this matter, but as far as our jurisdiction, he has had someone here representing his department each and every time. But we did mention, I believe, from the last meeting about having him here. So when we draft a letter, it should be, all that kind of stuff. Madam Clerk?
No, that is not in the minutes, just the actual motion of drafting a letter to ethics.
Okay, so you don't remember that. Okay. Member Pelpel, so let's continue with...
Okay, so I think where I'm headed with this is to adopt some version of this document as our referral. I'm very open to changes. There are some things that I know are not correct in here, and I'll go through those in 1 second. Just for where I am, I'm not sure that I consider this a willful failure. I think that this issue of conflicting advice from the city attorney and from this body gives rise to a question of whether the violation is willful. If the rest of the body believes that it is willful, that's fine. I'll, just not support that portion of the determination or the referral. But if that's the case, I think some additional facts or narrative needs to be included in here, because I didn't have enough of a basis to recommend that the violation was willful. That's just where I am. But I wanted to go through some other parts of this. And I'm not sure if the parties have seen this. I mean, we're talking about a document.
So let me hold, because in the last meeting, just as a point of order, this was decided that Member Sims was going to draft this with help from Member Washburn and with help if he needed it, go through Attorney Threet. So I'd like to give it back to him because he is responsible for it. So would you like to continue this since you didn't get an opportunity for the next meeting, or would you?
I mean, I'm hesitant to continue it just because I feel like obviously there's parties here that have been have not been made whole in that they still don't have these documents, and I think the more time we delay it, the more time, the more opportunity it goes to him not getting made whole and getting justification either for why they feel like it's in the public's interest to withhold these documents, even though he's made clear statements that his reasoning for wanting the contact information is to determine whether the Parks and Recs had followed their proper procedures and whether the government had followed its proper procedures. And that's the only way he could determine if that was the case, by having these documents. So there is, I mean, the document as written, I have a problem with saying essentially that if the city attorney says that you can withhold, and then we find that you did not have proper justification or you should not have withheld, then we cannot find essentially a willful violation because you had a pass from the city attorney. I just don't, that doesn't sit well with me because it basically gives department heads either justification for withholding more than they should withhold, or gives the city attorney an opportunity to mask legal opinion when their legal opinion may be incorrect in terms of our interpretation of the Sunshine Ordinance the Sunshine Ordinance. So I have a problem with that. I do think that, for example, if a city attorney tells or gives advice to a department head that embezzlement is legal and they embezzle, and then they're brought up for civil charges for embezzle and criminal charges for embezzlement, they don't get off, or they're not free and clear because they took the advice of counsel. It just doesn't work that way. So I don't think they should be free and clear because they followed and took the advice of counsel when we don't even know if especially because the record is pretty bare, because we've been made clear that the Park and Rec did no investigation of why he needed the contact information in the first place, or they made no effort to contact the individuals to see if they were okay with releasing their contact information based upon the facts. So I think under those circumstances, I think a willful violation should be found.
So this, just a point of clarification. Since this has already been voted on and we voted to send this to Ethics Commission, this letter is just
No, we have not yet voted.
the motion to refer this matter to the Ethics Commission. Oh, this is you saying this in this letter?
That's him.
Yeah,
saying
we
that.
have not voted.
So,
on
okay,
this yet.
so...
We continued the matter.
Okay, so we continued, so I guess what I would like to see is where would we like to see this go? And then this letter was just to support what we sent, wherever we sent it. So before we get to all the details and all the stuff about that, it's important to know what we would like to do for this. It was referred back to us, so where would we like this to go? Attorney 3.
Madam Chair, members of the task force, I just want to clarify, I believe what was under consideration at the last meeting, it appeared that there was a majority to support referral for violating the order. And the question was whether there could be findings to support a finding, a legal conclusion that there was a willful failure, which is more serious. So there was a lot of discussion around that, and also about the need, if you're going to make an enforcement referral, to make findings of fact to support the referral. And so to come up with a list of those findings, it makes it a stronger referral, and it makes it less likely that it can be readily dismissed by the enforcement agency that it goes to. So I don't believe a vote was actually taken. I think it was evident from the discussion where the votes lie, but there was not an actual vote.
Okay. Thank you.
And I just wanted to add, this might be helpful in understanding the issue of city attorney advice in these areas. I have no knowledge of the city attorney advice in this case whatsoever, but it's been my experience from advising clients and also being on the receiving end of such advice when I was working at the Board of Supervisors that the city attorney's office does not simply say, yes, you can do that, it's legal. What the city attorney tends to do in providing such advice is lay out the different criteria and how they may or may not play out under different scenarios if the department took a certain course of action. So if that's what happened in this case, I think it's a little bit difficult to say the city attorney said we could do that. They probably advised that under certain circumstances the department laid out, it may be permissible. And not that they had to do one thing or another.
And I was going to say, I think under those circumstances, and I'm glad Attorney 3 elaborated on that, if they had read the city attorney's, I would say, December 19th, 2012 response to the complaint, which I assume is probably part and parcel of the advice they received from counsel. Of course, I probably wouldn't be, I don't know if I'd be privy to the exact advice they got to counsel through attorney-client privilege, but they would clearly see that there's case law in there that states that there's not a blanket exception, there's not a blanket rule that the telephone records or the addresses are never released. And I think from the testimony that we have received from the Parks and Recs, they have taken that as their go-to, essentially as their policy regarding especially this case. That essentially that there's never an exception to it. Now the city attorney's own memo doesn't say that. It says there are exceptions. It finds that the exceptions aren't. I think the words they used were, don't support the public interest of supporting disclosure. In this case, of course, we found very differently.
Okay. Is there any more comments? Because we're going to come back to this once we vote on what we want to do. I'd like to offer the respondent opportunity to offer any kind of final statement, conclusions, or anything of that sort?
Mr. Sims, I thank you for
Respondent first.
Oh, I'm sorry.
Respondent, yes, sorry. Respondent. Olive, is she there?
Yes,
Can't
she's
see
way
her.
back, she's waving us.
Does she have anything, nothing to say? Okay, thank you.
Mr. Sims, thank you for not, for being considerate and not wanting me to come back, but I don't mind coming back. I don't want you to take an early vote just because, just to speed it up. I'd rather it be done right, considering that the Ethics Commission has never backed you up once. I think this should be, done as the city attorney suggests, correctly. And if you need more time, please don't hurry it on my account. And I wanted to mention something else, but now I forget. I also think that you ought to give Phil Ginsburg notice for the next hearing so that when you do the referral, it will be for him. Or I don't know if the deputy city attorney, is there a process for me to amend my complaint and make it against Phil instead of generally against, I don't see any point of you sending this against Rec and Park in general. I think that's pretty useless.
Well,
It'll be useless for you and useless for me to attend, unless you find the correct way. Even if you ask me to refile the complaint, I will do that. But find the correct legal framework to send this properly to the Ethics Commission to see if they will back you up on one case at all. And that's all I wanted to say. So, don't hurry it on my account.
Okay, thank you.
Madam Chair.
Member Oka?
If memory serves me correctly, we did decide that Mr. Ginsburg is responsible, being the department head of Park and Rec. So I don't think that the case has to be refiled, because he is the director of Park and Rec, and any complaint filed against the Department of Rec and Park has to be decided, responded to by Mr. Ginsburg. So I don't think there needs to be a separate filing naming Mr. Ginsburg as the complaint respondent. And the other thing that I need to say is, if what I'm hearing is correct, we have a big problem with Ethics Commission. And we need to do something about that, because if we decide that this was a willful violation, then that's what the letter should say. We should not let one member decide because he thinks it's because there's conflicting advice given. He thinks that this is not willful. One member should not be the deciding, because the rest of us, I for one, will not vote for a document that doesn't have the word willful in it. We have to decide once and for all, if ethics is not going to back us ever, we have to fix that, or somebody else has to fix that, because we are not subject to their finding. Our findings have to be sent to them, because that's what the rule says. And if they're not going to back us, then they're going to laugh at us all the way to wherever they go and have their drinks. I don't want that. That's not why I'm on this task force. And if we're not going to have the stomach to make our findings stick, then we don't belong on this task force.
Attorney Threed, I have a question. So regarding directing our letter directly to Mr. Ginsburg versus the department as we have, is that necessary? Do we need to refile? We don't need to refile. Mr. Bianchi does not need to refile something separate because for willful violation, it should be against a person, correct? Not against the department?
A willful violation is available under the ordinance for a department head or a managerial employee of a department.
Okay.
So those are the categories. Ms. Gong doesn't fit those categories. Certainly Mr. Ginsburg does. Mr. Ginsburg has supervisory responsibility over all those under his management for the entire department. But there is an element of intent involved in willful failure. So to be the safest referral, the most ironclad referral, you would want him directly to be notified. It might be sufficient that his agent, Ms. Gong, has been notified of what's happening and that we've discussed, the task force has discussed with her that Mr. Ginsburg might be found in willful violation. But, that's a closer question. So if you want to make it as certain as possible, you certainly should give him direct notice that the task force is considering holding him in violation for willful failure.
Okay. All right.
However, it is not necessary that there be a separate complaint filed. It's simply necessary that he have sufficient notice and the opportunity to provide information to counter the charges against him.
Okay, so we do have the option then, since Mr. Bianchi said that we could hold this to the next one, that if the administrator were to submit a letter, that we would send him, giving him notice that we are, with this referral, that it's directed towards him as a department head, because it seems that Ms. Gong said that she did not notify him about this. We could rest assured that we, as a task force, had done our part to make sure he, as a department head, knows what we are considering referring.
Given the pattern in this case, if you want to be assured that he gets notice, then he should receive an email or a written communication of some kind.
Okay. All right.
Then I would be inclined to, postpone the decision and move it back to the next hearing, giving notice to Mr. Ginsburg and giving me opportunity to use Mr. Pippel's draft as a base and then edit accordingly. And in that, I would draft a letter to give the option of finding willful versus non-willful, and then we can vote based upon that at the next meeting and determine as a body. But I can draft the letter and in consultation with Attorney Threed and
Member Washburn,
and then send it to Mr. Pippel to see his thoughts as well.
Okay. So I need a motion. Is there a motion on the floor?
I guess I'll make a motion that we
Continue
this matter until the next task force meeting, and at which time the clerk will send notice to Bill Ginsburg, the department head of Rec and Park, regarding this matter in the hearing, and
before,
yeah. As well as giving us time to edit and draft a proper draft order of determination to be decided at the next task force meeting.
Member Pippel?
I'll second, but I wanted to discuss a little bit.
Great. So you second, and then It's moved and seconded. Can I open up for discussion?
So I would just add a few points to that. I would continue to notify Ms. Gong, add Mr. Ginsburg, perhaps Ms. Ballard as well, who's her supervisor and is their Director of Policy and Public Affairs, as was...
You mean on the notice?
Yes.
On the notice, okay.
Although she would likely not be the person named in the referral. I did want to go through a couple of the items here that I don't think are in the file, so if we need to get them from either Mr. Mayanki or from Rec Park, that we make that request so that we can refer to them as attachments. The initial, and some of these are fill-in-the-blank items as well, and I apologize to Mr. Mayanki, I think I misspelled your name in this document. I try to get that right. And it wasn't even Mayanki that I misspelled, it was Dominican. Never mind. The initial public records request, I believe, was November 22nd. I think we have pieces of that in email. I'm looking if we can get the initial request itself. The initial response was, I believe, December 12th. Is that correct? Somebody? Anybody? December 3rd, excuse me. The complaint was filed The complaint was filed December 12th.
Yeah, the complaint was filed December 12th.
Right, and we have that. That's in the file. The order we have, this paragraph that I have here labeled as background, that perhaps can be struck. I think that's interesting, but the rules weren't really discussed in the hearing, and so I'm not sure if we need to get into that. And if that's the case, then we don't need to ask for them, and we can just strike that paragraph. I think at the bottom, it was suggested that where we've got analysis, that should instead read findings. On page 2, the third paragraph, I think I actually was paraphrasing, and there is actual text in the letter from Rec Park about the Good Government Guide, and I'm looking for where that is here. The normally blah, blah, blah. Does someone have that?
Right. What? You're doing your own letter based upon that.
All right. Anyway, whatever page that is from the Good Government Guide, we should have that in the file. So those are the pieces that I was looking for. If we can get those from either the complainant or the respondent and have them in the file so that we can refer to them as specific attachments, I think that would help. I would note that the Ethics Commission has sustained the task force recommendations in a couple of cases. In particular, found a violation by Ms. Gong, and my intent was to not repeat that if there is a violation here, that it's a violation of Mr. Ginsburg. And so I'm trying to document and have a sufficient record to find that. I think holding Olive out is not the best course here. So that's kind of where I am.
Yeah.
I'm in support of the continuance. I think we should do this right, and then I think we will likely prevail at the Ethics Commission, which is where I'm trying to get with this. And whether or not, whichever way the task force goes on the violation being willful or not, that's the least of my concerns here.
Great, thank you. Is there any more comment from anyone on the task force? If not, I'd like to open up for public comment on this issue.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. If you look at all of the complaints I file, I always file the requests for public documents or access to public comment to the department head. And if that person decides to delegate it to someone else, it doesn't change the fact delegation is not abdication. They are the ones not only responsible to see that they follow the law, they are responsible to see that all the people under their supervision comply with the law, and their failure would be if they allow an employee to respond in a way which is inappropriate. So a couple things that have been mentioned. Number one is you need to have a particular person named, because the Ethics Commission has taken a very strict stand of we're not going to find a violation against a department. It has to be a person. And the second factor goes then into enforcement, which is it is not unusual for a department head to avoid responsibility to send a subordinate. And that person then goes in and falls on their sword. And even if the Ethics Commission, which in I think one or two cases, they did find that person in violation, they immediately said, well, this person is not a department head, therefore we cannot find a willful violation and we cannot take any enforcement action against this person. And because, and this is my hypothesis, I'll mark it clearly as that, if I'm the department head, I send a subordinate who can't be held accountable, they fall on their sword for me, I can get away with doing what I want to do, which is withhold a record or whatever it happens to be, and then I do nothing to that employee because I sent them out there as a sacrifice. So I always name, for example, with the city library, I send all of my public records requests and requests for meeting access to Luis Herrera, the city librarian. And he cannot then come back and say to me, well, it wasn't me, it was the Library Commission, it was the Secretary of the Library Commission, it was the Chief Financial Officer all over that did these things, and since none of them are responsible, then they're off the hook. So basically, it really comes down to responsibility. And I'm tired of mentioning this third time today. I was in the Navy, and one of the things you learn when you're in the service, if you're the commanding officer and something happens on your command, you're responsible, period. You may not be the person who did it. It may not be your fault that it was done, but you were the one responsible for whatever happened and the outcome. And if you ever walk into a non-judicial punishment or a court-martial and you say, I'm the commanding officer, but I'm not responsible for something that happened on my ship, they would laugh you out of the place immediately, and that would be another charge for them.
Thank you. Is there any more public comment on this item?
I just wanted to ask how I get the documents that David Pupil asked for to him.
You can give them to the administrator.
I don't have them with me. Can I just...
Yeah, can you email them, or you can drop them by the office, or whichever way you want to.
SOTF at
SOTF.
SFF. Don't send them to me, send them to the office. Thank you.
Great, thanks. If there's no more public comment's closed. I'd like to take a vote. Mr. Hook, can we do a roll call vote?
On the motion to continue to the next Sunshine Ordinance Task Force meeting, and to be sure that General Manager Ginsburg is notified directly.
And Ms. Ballard.
Ms. Ballard.
And Ms. Ballard.
Thank you.
Member Nee.
Aye.
Nee, aye. Member Pilpel.
Aye.
Pilpel, aye. Member Sims.
Aye.
Sims, aye. Member Highland.
Aye.
Highland, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Fisher.
Aye.
Fisher, aye. Chair Grant.
Aye.
Grant, aye. We have a vote of 7-0.
Great, thank you. So we'll see you at next month's meeting, and we will have sent out the appropriate stuff. Thank you for coming again. Can you go to the next item on the agenda, please?
Item number 7. Complaint filed by Michael Fondanova, representing Glad Tidings Church, against the Office of the Assessor Recorder for allegedly failing to provide complete records associated with Glad Tidings Church and San Francisco Teen Challenge. A, determination of jurisdiction, a complaint filed by Michael Fondanova, representing the Glad Tidings Church, against the Office of the Assessor Recorder for allegedly failing to provide complete records associated with Glad Tidings Church and San Francisco Teen Challenge.
Great, thank you. So I don't know if jurisdiction has been accepted by both parties in interest. Let I'm sorry, who? Mike, are you Michael?
I am.
Oh, okay. Have you, are you?
Never been here before.
Okay, so, well, you don't have to get ready, because all we're doing right now is about jurisdiction.
Okay.
So I just need to make sure that it's accepted by both parties. Who's here representing the assessor's office? Hi, so do you accept jurisdiction? Yes. Okay, and then you obviously filed it, so you accept jurisdiction. Okay, great. Can I call for a motion to accept jurisdiction?
So move.
Second.
Thank you. It's been moved and seconded. I'd like to pass this without objection.
Public comment.
Members? I'm sorry, can I get public comment on jurisdiction? If not, then this has been passed without objection. Okay, so now, Mr. Fondanova, the way that this works, just so you know, is that you will get 5 minutes to kind of give us your side of what's going on, and then we'll give the respondent 5 minutes. But go on, so you have 5 minutes to tell us about this case and what we should know.
May I read the remainder of the item? I didn't read section B.
Oh, you can, it's okay.
Okay,
The
sorry.
hearing complaint, thank you, no, yeah, thank you.
Hello. I'm not sure what I'm supposed to... Yes, members of the task force, Madam Chairman. I left my Robert's Rules of Orders at home, so thank you for being here. I actually am very grateful to have you guys here. I know a lot of people were upset. It feels like nothing's getting accomplished, but it's nice to have someplace to go. Basically, the nuts and bolts of this complaint are I want to see the files that pertain to our church and to a ministry we know as San Francisco Teen Challenge, and they did not provide what I feel was the full file, the complete file. Some of the notable absences from the file would be interoffice memoranda, and I can talk about why I want that particularly, but that's the nuts and bolts of my complaint. I just want the file. I feel like they've left out correspondence amongst themselves. Specifically, Francis Nguyen is the person I made this complaint to. This is the Deputy Assessor Recorder, and I want to see his correspondence, especially with his employee, Aleda Graham, who was the head of the exemptions unit at this time. She's now moved on, but those two people are particularly of interest in this because I believe that they, well, there's reasons I have behind it, and I can go into those if you like, but that's all I have to say as far as the complaint.
Okay, you'll have an opportunity. We'll question you after,
Sure.
if that's all you have. That's cool. Is there anyone here to support you, offer any facts or evidence in addition? I can't say.
No.
Okay, thank you. At this time, I'd like to ask the respondent to come up, and you two have 5 minutes to kind of give us your side of this case.
It's also my first time here.
Okay, it's okay.
So, members of the task force and Madam Chairperson, to my understanding, well, let me introduce myself. My name is Margaret Singh. I am the replacement for Aleda Graham. I am the manager for exemptions and public service. I am here on behalf of Francis Nguyen, who has now retired. But based on the information that he has provided me and on the advice of counsel, our office cannot disclose the official information and identity of the person who reports the allegedly unlawful activity under sections 1040 and 1041 of the California Evidence Code. Briefly, to give you some history, on February 27th of 2013, our office received an email request from the Glad Tidings Church for public records, including files, emails, meeting notes, forms, filings, and so on of Glad Tidings Church and SF Teen Challenge. On March 4th, we wrote to inform the Glad Tidings Church that we have records responsive to this request. Our office provided a complete copy of all records in our assessment file and all correspondence between the Assessor Recorder's Office and the State Board of Equalization, as well as the State Labor Board. On March 11, 2013, we received an email clarification from the Glad Tidings Church requesting correspondence between our office and the informer. On March 28, 2013, we wrote to inform Glad Tidings Church that we have records responsive to this request, but we declined to produce them based on the official information and identity of informer privileges under the California Evidence Code sections 1040 and 1041, which authorizes us to keep confidentiality of the identity of the persons who reported the allegedly unlawful activity. Thank you.
Thank you. Is there anyone here to offer any support or facts and evidence for the respondent? If not, then I would like to open it up to the task force members. Question? Member Nee.
Yes, Ms., I'm sorry, what was your name, please?
Singh.
Ms. Singh. Okay, I do have a question for you. This is obviously a whistleblower matter, but where procedurally are we now with the investigation? Is the investigation complete or is it still ongoing?
To my understanding, it was completed.
It was completed.
Yes.
Okay, so the whistleblower, the person, your informer, has your informer requested confidentiality?
That I do not know, but I can find out for you.
Are there any more questions? Member Pilpel.
So I'd like to try to clarify, is this dispute about disclosure of records or redaction of records, or both?
From what
I'd like to hear from both sides, so 1 second.
From what I was told, it was requesting for the informant's contact information.
Okay, so it's your belief that all the records have been properly disclosed, but where the contact information was properly redacted, and that there are no records that you're withholding in their entirety? Is that what you're telling us?
According to what Francis Wynn provided me, he indicated that all complete copies that are within the assessment files and all correspondence between the Assessor Recorder's Office and the State Board of Equalization, as well as the State Labor's Board, were provided.
Okay, I'm not sure if that's it. Hold on a second. Let me hear from the complainant.
Sure. You guys can hear me okay, right?
No, you actually need to be on the mic so we can record it.
I just want to clarify, my desire is not to ascertain the identity of the person who started the Scorched Earth campaign 5 or 6 years ago. I'm pretty familiar with them. But I do want to see the inter-office correspondence. So she's already declared that they have provided correspondence with other people, but they have not provided correspondence amongst themselves. So when they were talking about what we're going to do with Glad Tidings Church, I want to see that information. This is key for me because I'm actually going through an appeal process to overturn their improper removal of our exemption, our property tax exemption. Ms. Singh, this is the first I've heard that Francis Newton retired, which honestly I'm excited about.
Okay, I think you answered my question.
Okay.
Let me go back to Ms. Singh.
Yeah, go ahead. Go ahead.
So if the issue that the complainant is now raising is that there may be inter-office email, are you aware of any?
I am not aware of any.
Okay, so...
But let me tell you this. Today is only my second day on the job.
Oh, well, your second day with the city or your second day in this position?
Second day in this position.
Got it. You've been with the city for
11 years.
Okay, that's cool. So there may be records that you're not aware of?
Possibility.
Okay. If there are, in the case of an investigation where someone comes to you and says, we believe da-da-da-da, right, and we're telling you this in confidence, that's a Evidence Code 1040, 1041 matter. Do you believe that at some point when that investigation is concluded that the information provided, perhaps with contact information redacted, can be disclosed to a third party?
As long as the informant's contact information is redacted, yes, that can be provided, but I would have to consult our counsel.
Okay. Do you believe that that has been done in this case?
I cannot say.
Okay. So at a minimum, we're probably going to ask you to go back and check that, both that the complainant, the underlying complainant information, albeit redacted, is disclosed, and if there's any inter-office communication, again with appropriate redactions, that be disclosed, because it sounds like that's what the complainant is looking for. Yes?
Yes.
Okay. That's where I am.
Okay. Member Nee?
Yes. Who asked you to attend this meeting today? Who is your supervisor who directed that you attend this hearing today?
Actually, it was Frances Wynn who instructed me to attend.
Frances
Wynn?
Wynn? And is she still?
He.
Okay. He's
recently retired.
Recently retired. So who is your current supervisor?
My current supervisor would then be Kimberly Kimura.
Okay. All right. Kimberly?
Kimura.
Okay, and is she acquainted with this entire matter?
I believe Frances may have briefed her, but again, I've only been on the second day on the job, so I don't know what.
When did Mr. Wynn retire?
Last Friday.
Okay, Madam Clerk, when this matter came before your good office, to whom did you notify about this hearing?
I'm not privy to information right now. I have to look into the file to see. I mean, this was filed how many, months ago? February. So I'd have to look in the file to see who exactly it was sent to.
Okay.
Do we have the file here?
Just yeah, give her a second.
Okay. Mr. Fondanova, with whom have you been dealing at the office at the assessor recorder's office? Is it Mr. Wynn or his successor who?
Well, I've actually had meetings with the assessor, Phil Ting, when he was in office prior to his moving on, as well as recently with Carmen Chu, the new assessor. So I've met with both of them. I've also met, predominantly Frances has been the person that I've talked to throughout this whole process, the person who's been sending us, notices and things like that. It's all come from him. So he's been the primary person, but in several face-to-face meetings we had, Leda Graham did attend, who as the head of the exemptions unit, which is now what Ms. Singh's occupying her position, I suppose.
All right. Thank you.
Okay.
Member, I'm sorry, Sims. Sorry.
I guess I have a question for the complainant. Yeah, Michael. So you initially asked for what?
I asked, I can tell you exactly what I asked for.
And on the date? On what date?
February 27th, I requested, would you be able to send all your files on Glad Tidings Church and San Francisco Teen Challenge? We'd be happy to pay whatever fee is necessary to have the complete files, emails, meeting notes, forms, filings, etc. sent to us, or alternatively, I could pick them up in person. We'd like to have those files before we meet with the acting assessor recorder. At that point, they were asking us to meet, and so I wanted to make sure I had files.
Okay, so that wasn't an immediate disclosure request, or was it not?
I'm not sure what that means, immediate disclosure.
It wasn't. It was just a regular request. Okay.
Right.
And then when did they respond?
Let's see. They responded on March 4th. They notified us that they had located records response to our request. I went and picked those up on March 6th, which I have here. And after reviewing them, it was clear that I was missing several records of note, some of which I did clarify with them, and they did provide. She mentioned that they had already provided the state, their correspondence with the State Board of Equalization and the State Labor Board. In fact, they had not provided that in this file, and I had to additionally request that, which made me want to come before this task force today, because it seemed that if I did not specifically request a document, I was not going to receive it. And so
part of your complaint is that your March 4th production by the assessor's office was incomplete.
Correct.
And that they withheld initially
Exactly.
until you asked for more specific documents, as I see like on your March 21st letter.
Right.
You're asking for documents that they actually cited in their, I guess, a hearing or something. And those documents were provided to you eventually.
The documents I specifically requested were provided with the exception of some things that they felt fell under privilege or some sort of law that protected them from providing them.
And the privilege documents were
things relating to the identity of the complainant, the initial complainant that complained against our church.
So essentially, what you may be missing, at least, that they have not provided, are documents that reference or mention the identity of, because I'm just assuming here, you didn't receive any redacted documents. Were any of the documents you received redacted?
Not in this file. There may be some redactions in some of these some of this correspondence, but I've received redacted documents from them in the past, having requested, like prior to ever coming to the Sunshine Task Force, I requested a couple of documents of correspondence in which they had redacted the identity of the person, and I'm fine with them redacting it. I don't care if they redact it. I just want the document so I can show in my appeal process the kind of the evidence, the garden path they walked me down to get to this point.
So there may or may not be, we don't really know yet, but there may be documents that are outstanding that evidence the...
There's definitely evidence that there was basically I guess a hypothesis, my proposal, my accusation is that there's correspondence between Aleda Graham and Francis Nguyen at the assessor's office talking about what they're going to do with Glad Tidings Church in order to remove this exemption. And I would like to see that documentation, because what they sent us and what they asked us to do, which we were very faithful to do, led to the removal of our exemption, despite them telling us, oh, if you do this, your exemption will remain in place. So we did what they told us to do, and then our exemption was removed. So I want to see the information behind that, so when I go to the appeals process, I can say these people...
So you're saying there's specifically a correspondence between one person...
Exemptions Unit Director and the Deputy Assessor Recorder.
And you're saying in your documents you have right now, that document does not exist?
Nothing. There's nothing between the two of them.
So what makes you believe that document does exist?
Our church has been in San Francisco for 100 years. We actually celebrate a 100-year anniversary this year. Probably exciting. Thank you. This is what they provided for us. Does that look like 100 years worth of filings to anyone here? I don't know. Me personally, I thought that we might have been missing a few things. So that's why I'm concerned, and that's why I came to this task force. It's like, if this is all that you have, okay, but when I requested specific documents, they provided them, so I know that there was more even at that point. And now I'm left with the question, what aren't you providing? What is there that you guys have not said? I've already requested inter-office correspondence and memorandum, so why have I not seen not even one? So, I'm sitting in a meeting with Aleda Graham and Francis Nguyen, who've obviously talked about this case. Why didn't I see their notes prior to that meeting? Why don't I see their notes for that meeting? Why don't I see at least an email saying, hey, I'll see you at the meeting at 2 p.m.? I'm not seeing any of that stuff. Is that clear?
Okay. Sir. Respondent. So, as far as you don't know... What you've been told is everything that we have, we've given to them. That's what you've been told?
Yes.
Okay. But you don't know what was the reasoning behind the March 4th production lacking documents that should have been produced.
I was given a brief summary.
You were what?
I was summarized.
Okay, and what was your summary you were given?
Francis Nguyen told me that a portion of their exemption was removed based on an activity that occurred on their premises. And the reason why I was removed because an informant submitted evidence, such as photos and a report. And so based on that, they removed it.
So those photos and evidence, all that stuff that informant submitted, was that given to him?
I don't know. I can't answer you.
Okay. So we know there's photos and evidence and other documents that that was given by the informant that should have been produced, provided that the redaction was done?
But the contact information.
was properly done, especially since the enforcement procedure is over, correct?
I believe so, from what I've been told.
Okay.
So I'm reading here the California Evidence Code, which indicates that official information means information acquired in confidence by a public employee in the course of his or her duty.
So was that,
Because based off what Francis Wynn is informing me is under the sections, which I just recited partially, that we cannot disclose the official information and the identity. So it's not just the identity.
Madam Chair,
Member Popo?
if I might for a moment to Deputy City Attorney 3, can you help us a little bit on Evidence Code 1040 and 1041 and the question of whether or not items submitted related to an investigation are permanently?
yeah, whether there's any exceptions to those as well?
Through the chair, I cannot help you on that at this time. I did not research it or prepare it because it was not an allegation of the complainant's complaint. His complaint was that he didn't receive documents. It wasn't that the ones that were exempted or claimed as exempted from disclosure were not provided. So it was not a part of the research that I did for the memo.
That's fine. In general, is there something you can tell us about the official information privilege and whether that's absolute or?
What I would have to do is do some research on my iPhone. I don't think that would be a very productive manner of trying to respond to you at this moment.
Yeah.
Okay. Good answer.
It just seems to me that there are some documents, because I thought you were going to explain for me, because you kind of went a different direction. I went with you, which is great because now I'm getting, I guess, more enlightened to the situation that occurred. But did he ever explain why the March 4th records were incomplete? The March 4th production, the initial production, was incomplete.
He's telling me it is complete.
No, there was additional documents, it seems like, produced after March 4th. But there was the first production to him where he asked for everything, and then he said, no, you didn't give me everything. You actually missed this, and these other items.
Right,
and then it seems like you produced more after that, correct?
Nothing was produced. So on March 11th, he indicated we received an email clarification from Glad Tidings Church requesting for correspondence between our office and the informer. And then on March 28th, we wrote to inform Glad Tidings Church that we have records responsive to this request, but we declined to produce them based on the official information and identity of informer privileges under California Evidence Code sections 1040 and 1041, which authorizes us to keep confidential the identity of the persons who report the allegedly unlawful activity.
Okay.
Not exactly.
Who's asked a question? Member Popo?
Well, if I could just clarify, going back and forth with the emails and the letters, there was a letter sent by email from your office dated March 14th that says at the end, regarding communication with the State Labor Board, we've conducted diligent search and have found 4 documents responsive. Here they are. On March 28th, it said, we have found some additional records responsive, but we're declining to produce them. So that was all, I think Member Sims is on the right track here. That was all subsequent to the March 4th response to the initial February 27th email, which is in our packet at page 189, which, I read rather broadly to say, please send me all your files on Glad Tidings Church and San Francisco Teen Challenge. We're happy to pay whatever. We want everything, complete files, emails, meeting notes, forms, et cetera, which, kind of says, go do a big search and tell, we're happy to pay it. And later on, it indicated that at least 380 pages were found for a total of $38. So there was, some attempt. I guess, can you tell us in general when your office gets these sorts of requests, whether it comes from a taxpayer or a non-taxpayer, what type of diligent search is done, whether it's by address or by subject matter or a combination of search? How does this happen in your office?
Again, I've only been there for 2 days, so I can't really answer you.
Okay.
I had someone here with me, but he had to leave.
Yeah. Okay.
Member Sims.
Can the complainant come up? So going back to your March 21st, and this is kind of my last question, I apologize for belaboring this. Going back to your March 21st letter, you mentioned a copy of the August 1st letter from the BOE that you, Phil Ting, and a latogram cited repeatedly. Did you ever receive that?
Yeah, that was one of the documents I did receive that was
So
redacted.
you received that after March 21st?
I don't have the document right in front of me, but if that's the date it says on it.
But yeah, you say you received it, and I'm saying you emailed them saying specifically that.
Yes.
You didn't receive it on March 21st. So you received it before March 21st, or did you receive it after March?
They did not provide that document pursuant to that request. They actually, I think they mistakenly provided it. And because later when I requested it, they refused that request, but I found another place that they had sent it to me. So Aleda had sent it to me redacted early on, and I had requested they send it again because I couldn't find it, but then I found it. So that was just a great example of some of the confusion surrounding what they have and what they don't have.
And then this other document, correspondence surrounding your inquiry that you referenced on October 15, 2012 email, in which you stated we contacted the State Board of Equalization.
Can you repeat that? I'm sorry.
It says, it does not include any correspondence surrounding an inquiry you reference in your October 15, 2012 email. Did you ever receive that?
If that was made on March 11th, I believe.
March 21st.
21st?
Yeah, or you specifically referenced it on the March 21st letter.
Okay. Yeah. When they provided that one file, and then I said, well, some of the things that I noticed already that are missing are correspondence with the State Board of Equalization as well as correspondence with the complainant. And then they responded with 4 documents of correspondence with the State Board of Equalization and said they're going to still look for the things with the complainant. Since that point, they've not provided anything. So that was in March, the beginning of March. They did not provide anything beyond that. They did say, oh, well, just so you know, we're not going to give you anything of our correspondence with the complainant because of privilege or whatever. But we've already provided you with everything on the Board of Equalization and Labor where they have. So they said, so when I referenced that and asked for it specifically, they still would not produce that Board of Equalization or State Labor Board correspondence.
Okay.
Member Pilpel?
So I hate to suggest this, but I'm inclined to continue the matter, ask them to do a further search, and see at the next hearing if after a further search, after having been on the job for a month and 2 days, we can find some more stuff and see where we're at that point. I don't have enough information to determine whether there was a violation or not, whether we should send them off. I think sending them off to go do a further search would be warranted. It doesn't sound like there's a huge issue with redaction. It's just the
document.
Yeah, it's the completeness of the search, and I think having clarified that it's everything related to the church teen challenge, that address, correspondence, anything they can dig up beyond the 380 pages plus the other 4 documents would be great. Ms. Sang, does that make sense, what I've just expressed?
Yes, I can do that.
Okay. So is a motion to continue?
Or just to throw something, just to throw something else out there, we could find a violation, send it to compliance and amendments, and then that way it forces, if there's something that there is some information or documentation that is available, we would find, and it could happen there, and if they don't have it, then we'll find it there that they don't. They're going to say they've given everything they have, but that way we've moved it forward rather than continuing it, because at the end of the day, we're still going to, I understand what you're saying,
Right,
but I'd like to throw that out as an option as well.
I understand. I guess I'm not yet there because I don't feel that there's enough
For a violation,
If I felt that, there really is stuff that they have that hasn't been provided, and there really are documents at issue. I'm not sure if that's true. It may be, it may not be.
Well, it's up. I don't know if I can...
Hold on one sec. Member Nee, did you have something? I saw your...
I would have a problem finding a violation without knowing more. There's an awful lot we don't know, and I think that in itself is rather alarming in certain ways that I won't get to right now. I think we need to hear first if there are rebuttals, and then bring it back for motions.
Okay. Does anyone else have any comments or anything? If not, then I'd like to bring it up for the respondent. You get the opportunity to offer any concluding remarks or any, last comments or anything you want to kind of share with us. If not.
Going to go back to council, and that's about it.
Okay. Okay. And Michael?
Yes.
You have 3 minutes if you want to kind of sum up what you want us to know, what's most important.
Sure. I'm not really interested in a witch hunt or trying to get somebody in trouble. I just want the documents.
Yeah.
So whatever this task force feels is going to be most efficient in doing that is what I'd like. I'm really excited to work with Ms. Singh in hopes that we can find some of this stuff. I'm a little worried that some of the key players are now no longer with the assessor's office, and perhaps those emails are gone altogether now. But I am glad that God grants prayer, and he did move those people on to hopefully greener pastures. All that being said, I do have an appeal that I'm working with, and I'm trying to find as much evidence as I can to make this work. So whatever evidence you guys can help me get to show that the assessor's office did remove this incorrectly. I don't even necessarily believe that it was maliciously. I just believe that there was some miscommunications going on, and I want to show that to whoever I end up before and prove that point as clearly as I can.
Okay.
That's why I need this particular, as much evidence as I can find.
Got
Thanks.
it. Okay. Thank you. At this time...
Madam Chair, the problem I have is that if we're going to send this to compliance and amendments, we would be doing so presumably with an order of determination. Is that correct? What would be the finding and the instruction on that order of determination?
Right now, based upon some of the stuff that's in here, I think the finding, just from listening, that he asked for certain documents that had not been received, that I don't have in front of me, but because the finding that there was a willful violation of not giving the documentation that he requested, that's what I read from it. I know there's more information to be gathered, but that's what I kind of gathered from that whole exchange right now. And from reading the documentation, there's things that are missing. And at one time, they gave him something, and then he asked for it again, thinking it was lost, and then they refused to give it to him. So I find that there are some documentation that, willfully or not, were missing from that. So for me, I think that going to compliance and amendments moves I know we need to find a violation, but moves it to the next level of action.
So the order of determination there would then instruct the respondent to provide the document?
To provide the missing documentation.
Okay.
So, regardless, do we have a motion? We have to do something. So, do we have a motion to send it to compliance amendments? Do you have a motion to, do you want to, Attorney Threet?
Madam Chair, just a cautionary note, if the task force is considering finding a violation, it would be important that there actually be documents identified that you're ordering be provided. If there's some uncertainty about whether documents have still not been provided, then it would probably be better a course of action to wait to find out whether they were or were not. Because once the order is issued, the matter is determined. We're not going to revisit it. It will be a compliance and amendments, and the assumption will be whatever the evidence comes out at compliance and amendments, the assumption will be that there were documents.
Yeah.
And if the department came back at that point and said, you know, we have done a search, I'm more familiar with it, there are no other documents, then the task force really would have no option other than to say, well, you know, we issued this order and you're not in compliance.
Got it. Okay. That makes sense too. Okay. That makes sense not to. So understanding that, then that makes sense to me. So do we have a motion to continue? Do we have a motion? There's a lot of options.
I mean, is that what the individuals, everyone's kind of thinking, that we want to give opportunity to continue to give the assessor more time to
search for these documents?
And there is still also the question regarding the privileged communication of the informant, and whether that is actually, in this case, withheld on correct grounds, which I'm unsure of as well. And I don't know if we need more analysis, or if we can even get more analysis, because, as you said, he did not
request those
documents in this.
And we
said requested all documents. But
yeah, remember, at 23?
I'll just say it was not my understanding that it was seeking confidential information. I've done a little bit more looking at the subject, and the purpose of the Evidence Code 1041 confidentiality is so that if someone comes forward with a complaint that there's a violation of law, that they can remain confident that there will be nothing disclosed that could lead the person complaining back to them. And so that provision has been interpreted to allow confidentiality to continue even after the investigation is over. However, there is a balancing required under that section. So if the public interest in disclosure outweighs the public interest in the confidentiality, then under that section it should be disclosed. So there's no clear-cut answer here.
Well, I think one of the questions is, you claim Mike has claimed he already knows who this person is.
I do.
That's not your issue.
Yeah, it's not an issue.
So that's not an issue with you.
Again, and actually, just to be clear, there was a request for correspondence with the complainant, but that's not an issue here. That's not why I'm here before this task force. So they said, well, we're not going to provide that for you. I said, okay, fine, but I'd still like to see the interoffice memorandums. I'd still like to see whatever other correspondence there is between other state organizations or city organizations. I'd like to see some of the other stuff. And, I don't want to have to specifically request every document for a 100-year-old building, to find out where it is.
And I don't think you're not required to do that under the ordinance. But so I think the continuance should be based on giving the assessor more time to produce documents. Not saying that if they produce documents, they're just going to be scot-free from penalties from the sunshine or from this body. I think we would then bring it back up to determine what documents were produced or withheld, and then go from there.
Were they to Mike's satisfaction? So if we give you a continuance to the next meeting in October to see if you can produce any more documentation, if that documentation kind of meets what Mike's looking for, then we're done. And then if not, then that's when we could go to one of our other subcommittees, compliance or amendments or education, outreach and training, but I feel this would be a compliance if we didn't get the documentation. So with that being said, do I have a motion on the floor?
There has been a motion made to continue.
Oh, we did make a motion?
And it's been seconded.
Oh, okay.
No.
I didn't hear.
I will so move to continue.
Yeah, okay.
We talked about
It starts
it,
to
but we
run, I know.
hadn't done it yet. So
Yeah.
I'll move to continue.
Do I have a second?
Second.
Great, it's been moved and second to continue. Member Nee?
Yes, I would also like to send a notice of some sort, a letter memorandum of some sort, to Assessor Chu, stating that at all future hearings, task force and committee hearings on this matter, the assessor is obligated to send a representative who is knowledgeable. Ms. Singh is in a very unenviable position. We asked her a lot of questions. She was unable to answer. That's not her fault. This is her second day on the job, and I think for them to send somebody in her circumstance to this hearing is absolutely inexcusable. So I would like to, I would like us to notify Ms. Chu that henceforth any representative they send here will be knowledgeable, or we will find violation accordingly under Section 67.21E.
Great. Is there any more comments from members of the task force? Is there any public comment on this matter at hand? If not, I'm going to close public comment and...
So I just want to be clear, because last time perhaps we weren't. So the motion is to continue to the next meeting, requesting the assessor recorder to conduct a further search based on the discussion that we had, a letter or communication, as Member Nee suggested, will be prepared and sent, and that we will ask both parties to come back next month with an update as to where we are. No prejudice as to future determination, which could go either way.
Yeah, exactly.
Okay. Just so that, I just wanted to summarize that so that we're clear.
And what Member Nee added.
Including the communication with Member Nee.
to Assessor Chu.
Thank you.
Can we do a roll call vote, please?
On the motion to continue to the next meeting of the Sunshine Ordinance Task Force, send notice to Assessor Chu to provide, to send staff to our meetings that are knowledgeable of the situation, and to allow for more search of additional documents. Member Nee?
Aye.
Nee, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
Aye.
Fisher, aye. Chair Grant?
Aye.
Grant, aye. We have a vote of 7-0.
Great, thank you. So just for your own knowledge, this has been continued till next month's meeting, which is October 2nd. Thank you, I'm updating in front of me. October 2nd. So you'll get a notice from our administrator, both of you, about, what we discussed today, and so we hope to see you next month. But thank you for coming today. That's it. Thank you. See you next month.
Madam Chair, could we request a brief recess?
That's what I was going to say. Let's take a quick 5-10-minute break and come back. Thank you. And I was like, let's keep this going. Yeah, 5. You guys get your little snacks out. Yeah. No, he's here. He's here. And Petraeus. I don't know who Petraeus is. But Todd Davidson. Administrator, can you read the next item on the agenda, please?
Item number 8, complaint filed by William Clark against the City Office of the City Attorney for allegedly failing to provide a response to a records request regarding communications between the Arts Commission and the Office of the City Attorney concerning time billing for fiscal year 2010-2011.
Move to find jurisdiction.
Second.
It's been moved and seconded to find jurisdiction. Is there any discussion? Is there any public comment about it? I can't see. If not, then I'll declare the motion passed without objection. So I'm going to go straight to the next item. The complainant has 5 minutes.
Hello, Task Force members. I'm William Clark. This is similar to a previous case you had regarding the Arts Commission. And what I did is I sent a letter to the city attorney requesting all correspondence and records between the Arts Commission and the city attorney regarding the Sunshine Ordinance portion of this time billing for fiscal year 10-11. There were 73 conferences between the Arts Commission and the City Attorney's Office relating to the Brown Act and the Sunshine Ordinance, and the cost for that amounted to $14,280. And I wanted any correspondence between the Arts Commission and between the City Attorney's Office. And what I received from the City Attorney, I received 3 letters that were sent by Mr. Lazara to 3 different street artists. One letter was to me, one was to Mike Adario, and one was to another street artist. And those were the only records I received from him. And so I notified him that didn't respond to my complaint, and I stated to him that I felt that I should be provided with some information, because the Sunshine Ordinance states that any advice or conference or opinions between a department relating to the Brown Act, the Sunshine Ordinance, etc., is all public information that must be disclosed. And so what he sent me back was an email in which he stated that during the fiscal years that those were the only 3 records that he had regarding all those 73 conferences, that was the only public records they had. And he made a statement in his email that there may have been some covering sheets with some of this stuff, but that may have been destroyed. And I made this request about a year and a half after the fiscal year. And so what I'm saying to you is similar to the previous complaint, is that I filed a complaint saying that the department head did not keep accurate records in this case, and that if there are no further records regarding any of these conferences between the Arts Commission and the City Attorney's Office, that the public is being denied that information, because we're entitled to know everything that's being discussed between those two departments regarding public Sunshine Ordinance. And so I'm stating that even if there isn't any public records, there should be something written down somewhere describing what these conferences will entail and what the outcomes of them. And so I'm requesting that if anything else, that you find them in violation of not keeping proper records, and do a similar thing as you did with the Arts Commission, which is coming up at the EOTC, to sit down with me so that in the future the City Attorney's Office, when they have these conferences with department heads regarding the Sunshine Ordinance or the Brown Act, that there be some record filed somewhere that provides the public with an explanation of what was being discussed and what the outcome of that is. Because if they don't do that, then especially in this case, since it cost us $15,000, we have no way of verifying that they're not just stuffing the basket here and charging us more than is necessary. We don't know whether they have private conferences discussing things, because there's no information being provided to the public regarding any of these 73 conferences that took place for that particular year. So I would ask you to find them in violation of not providing me with any records, If those records don't exist, find them in violation of keeping improper records and send this over to the EOTC, maybe next month with my other hearing, so I can sit down with them and we can fix this problem.
Thank you very much. Is there anyone here that wants to offer any support of facts and evidence for Mr. Clark on this case? If not, I'd like to invite the respondent up. And you have 5 minutes as well.
Yes. First of all, my apologies. I had alerted the task force and Ms. Andrea that I will be leaving at 7:45, but I will stay till 7:50 and feel the wrath of my family members. But anyways, regarding this case, I feel like it's deja vu all over again. I've been in front of the task force, before the task force, ever since the beginning of my job here with the City Attorney's Office on this same exact case. It's been going on since 2010, 2011, 2012, and once again, we're here, 2013. Same exact case. The previous task force has found our office not in violation of the Sunshine Ordinance, and I think that was back in September 2011. Similar deal, that we were in violation, accused of being in violation of not turning over documents requested by the Clark brothers. And in this situation, March 7th, documents were requested relating to Public Records Act, Sunshine correspondences between the Arts Commission and our office. We turned over everything. March 12th, we turned over everything, all the documents. March 13th, the Clark brothers accused our office for not turning over the documents, and immediately they filed a complaint. We turned over everything. Our office does not want to be in front of the task force and be found in violation. And most importantly, doing a disservice to the constituents. We have turned over everything. And I just want to conclude by saying that this has been a repeated pattern with the complaints. I think there is a potential misunderstanding of how all this works, communication between the commissions, our office, what is disclosable and what's not. And in this situation, we have disclosed everything that our office can under Sunshine Ordinance and also the Public Records Act. Thank you.
Thank you. Is there anyone here that would like to offer any facts and evidence in support of the respondent? If not, then I would like to open it up for discussion by the task force members. Member Sims?
Well, I guess it's for both the claimant and the respondent. I guess to even kind of understand what wasn't turned over or not turned over, we'd actually have to have what was turned over and what documents were produced or not produced. Like, we don't have the documents that were produced.
Right.
Like, why don't we have those?
Well, I forgot to send the email over to you. There were, like I said, there were 3 letters, and I was looking for it through my file, and I couldn't find it. But they probably have it. I'm sure they have a copy of it.
Do you have it with you?
Yeah, we sent it, I'm sorry, the task force should have it.
Come up.
The administrators, we did send over, or I'm sorry, the administrators did share it with.
Can you talk on the mic just because it gets taped? Thanks.
I'm sorry, Ms. Andrea had forwarded to the task force members. So it's not just the letters themselves, it also includes exhibits.
Okay.
So that entire stack is what I have provided to the Clark brothers on behalf of the City Attorney's Office.
In here, is it? Am I wrong? Is that in our packet?
I've never seen any of the underlying documents.
Yeah, I have it. But I don't think, did everyone get it?
No.
What I have in the packet is page 217, and that was sent to me.
You guys haven't seen this before?
217 of the full packet.
I have the packet material. I haven't seen the underlying request and response, if that's what's being circulated.
Yeah, I see that, but the actual, I think I'm looking for the actual billing records. Like, this is the actual billing records right here, right?
I have a 3-page letter from Mr. Song. Starts in our packet on
There's an attachment there, which has the...
the actual.
Yeah, that. Right?
Oh, yeah.
I don't think any of the task force has that.
Can I jump in with a question while?
Yeah, sure.
Absolutely. To the Clark brothers, who are now affectionately known as the Clark brothers.
Actually, just so you know, William is the only one who filed this complaint. So.
We were having fun referring to you as the
Okay.
Clark brothers. Anyway, okay, so whatever they provided, what else do you believe exists? Because this is another one of those, we want stuff and, we think that there's more stuff than they gave us. What are you looking for?
Well, as you see on the billing, which is similar to the other case, there were 73 conferences that took place between the Arts Commission and the City Attorney's Office to discuss Public Records Act, the Brown Act, and what I would like is a record or the information as to what they talked about. What was the issue that was involved? There's no, and they're claiming that they have no record of any of this, and therefore the public cannot find out what was discussed between these two parties. And the Sunshine Ordinance clearly states that any communication between a department and the city attorney regarding the Sunshine Ordinance or the Brown Act or the Records Act is public information that is disclosable. So whether there's a record or not, I think we're entitled, the public is entitled to know that what was discussed. Otherwise, they can be giving legal advice to the department as to how to withhold public information and public records, or advising, in other words.
If they had a telephone communication or even an in-person conference and produced no record as a result, but they just talked, there may be no records from some of those meetings. So would you accept that they may, in some cases, have records, some from which were disclosed,
to be honest
and in
with
other
you,
cases they might not?
Honest with you, I don't. There should be a log somewhere that says if Howard Lazar talked to Adine, the city attorney, and spoke for 3 hours, because some of these meetings were for 3 hours, which cost us $800, that there's got to be a record, a log, a written memo somewhere in their office, a covering sheet somewhere that says what was discussed.
Okay, so then if I can follow up with Mr. Song. So we have seen billing records. We're aware that there are consultations that occur. In some cases, they're referring to documents or creating documents. In other cases, they may or may not be. Can you explain to us in broad terms how advice is given and when records are created relative to that advice as relates to this kind of thing?
Sure, I think this is what you had pointed out earlier. It's a conversation between the client and the attorney. And in this situation, I think we turned over the billing records. I think a few years ago, similar situation brought up by the same party. They were concerned. I think this is where the misunderstanding is. They believe that the billing, and I'm sorry, I'm not addressing the question, but I think this is the origin of where the complaint comes from. Same thing with the 2010 complaint, that these costs are trickled down to the street artist program. And I don't believe that's the case. What we provide is legal advice to to the Arts Commission. Our costs, I don't know how the budget works and how the street artist program charges I don't know how they administer the street artist program, and I think that's where the point of contention is, that the city attorney's office is billing for legal consultation for the Arts Commission, and the street artist program is suffering from it.
Okay, I guess that's not exactly where I'm going. I'm trying to understand when there's an item billed back to a department, presumably there's some time entry that's logged into the billing system. In some cases, there may be a document that was discussed or created as a result.
Sure.
And in those cases, you're saying that you've provided
absolutely
those records.
Yes, absolutely.
And in other cases where there was discussion but no document, you have no document, there was no document created, there was no document deleted or discarded, there just never was a document, they sat and talked for 3 hours.
That's correct. That would be correct. And again, we've turned all the responsive documents relating to this request.
Thanks.
Any more questions?
I mean, I just wanted to clarify, because I know this point has come up before, and basically the billing
Who's your question?
time slips, I don't know what billing system you use, there's a million of them, but whatever billing system you use, basically you're just printing out how it was billed and this is the only information that the attorney is putting in regarding the matter, and they're not putting in anything else, or are they putting in something else and you're redacting it? That's the question.
Sure. What you're seeing, Fund, is a good example of our billing record.
Yeah.
And just on the caveat, I guess, and not relating to this case, but for your information, any cases that are pending or currently in litigation, we would not disclose that on our billing if there were a public record request, but not in this case.
For current litigation, yeah.
Correct.
Yeah.
Are there any more questions from the task force? Member Oka.
Yes. Just a minute. Mr. Clark, from what I'm hearing, let's see, you say that there were 73 conferences between the City Attorney's Office and the Arts Commission regarding the sunshine?
Not exactly. What they sent me was 3 copies of 3 different letters that were sent from the Art Commission to 3 different street artists. One letter was to me, one letter was to Michael Adario, and one letter was another street artist. Those are the only 3 documents that I received in this request from the City Attorney's Office, nothing else.
Where are you sure there were 73 conferences?
Yes, that's on the billing, on the time billing. It's all stated. Each time there was a public records request, it states under each one that it was Public Record, Brown Act, Public Records Act. So I literally counted all of them. On the sheet that I gave to you, it's kind of hard because I misprinted a couple of the pages sideways, but I counted them all.
For the City Attorney's Office, please.
He walked out.
Are there records kept in writing on each of those, each meeting that you have? I'd like, wait a minute. He's gone.
I think he's gone. I think he had to walk out.
He had to, yeah, as he mentioned.
Okay.
7:40.
I think he meant 6:50.
I think he meant 6:50, yeah.
I think he meant that, so, but we can
Or he went to the restroom.
continue. No, I think he
To answer Mr. Oker, I believe he stated that they didn't keep any. I don't know what his answer is. I'm not going to answer him. But this was the time billing information, like you said, Mr. Sims. That's the only information that I was provided regarding public records conferences between the department heads and the city attorney's office. Okay.
Okay.
All right.
He's mentioned that he had gone? Yeah, I believe he mentioned he needed to leave it. He said 7:55. I think he meant 6:55. He's not there, right?
Coat's still there.
Oh, it is?
Oh, that's not, whose stuff is that at the back?
He's come.
Okay. Okay, so, for some more information, or at this time, I would normally invite the respondent up.
And I understand, but since he's not here, then it's my turn.
It's your turn. So you get
okay,
3
again,
minutes.
I want to just reaffirm that, first of all, the first time a similar matter that was heard regarding the city attorney's office, the task force actually found him in violation. This was in the old task force for a similar offense. And also, I just want to say that the only thing, he stated that they turned over all the information, but like I said, the only thing they turned over to me was the time billing sheet, which provided no information about what was discussed when those two individuals sat and talked about public records, information, or anything regarding the Sunshine Ordinance. It's all under the category Public Records Act and Sunshine Ordinance. And that's what my request is based on that they cannot claim a privilege, an attorney-client privilege for that information in those documents, because the Sunshine Ordinance clearly states under, I believe it's 67.24, that, and 67.24B subsection III, that the advice given to a department by the city attorney regarding the Brown Act or the Sunshine Act or the Public Records Act is all public information that must be disclosed. So all I'm asking them to do is to provide a short summarization or a document of what was discussed during those meetings between the two parties, because otherwise this could all be just made up. There's no proof that they discussed anything, and since it wouldn't matter so much, and I want to say it isn't about the payment. The fact that this cost the street artist program $15,000 is relevant, but what's more relevant is the fact that we're not getting any information about what these conferences entailed and what the essence of those meetings involved and what the outcomes of those meetings were involved. If there was an outcome where he gave advice to the Arts Commission regarding any of those 73 conferences, that advice is disclosable to the public, and we're entitled to have that information. And that's why I'm saying I would like you to find him in violation of the other section. I believe it's 67.297A for shoddy record keeping, and help me get the city attorney to provide us with more information in the future regarding these Sunshine Public Records Act conferences.
Great, thank you very much. At this time, I'd like to ask the members if there's a motion to find a violation of the Sunshine Ordinance. No? Okay, if there is no motion, then I am going to take public comment at this time.
Robert Clark. You know, what's typical is what this city attorney has been doing to my brother and I for my brother and me for years. We ask specific questions. We ask the question. We want all the communications between the Art Commission and the city attorney. What does the city attorney do? They do what they did in the other case that we came in front of this task force with. They twist the question, and then they answer the twisted question, and then they say, we've provided all the information. We didn't ask them for all communications between the Arts Commission and street artists that were sent over to the city attorney. My brother, asked specifically for all communication between the Arts Commission and the city attorney. The city attorney sent 3 letters from the Arts Commission to street artists. 0 documents between the city attorney and the Arts Commission. And then he has the nerve to walk out of here because he has some kind of commitment where questions can't be asked to him by this task force. I find it outrageous what the city attorney has been doing for years. What I want to say at this time is, regardless of how this task force votes, my brother and I, have the evidence to prove that the city attorney's office has been covering up illegal amendments of ballot measures, has been writing fraudulent city attorney opinions to cover a cause of action and to cover up the fact that over $200,000 of the street arts money has been embezzled. We have the evidence to prove that this is a classic case where they twist the question and come before these boards and commissions and say, we've done everything. If they've done everything, you cannot tell me there isn't one document in those 73 conferences that says, we've discussed this matter with Mr. Lazar, and this is what we advised him, this is what we concluded he should do. There should be one document somewhere over at the city attorney's office, and I'm claiming that this is a deliberate, willful attempt of them to refuse to provide the documents.
Thank you. Is there any more public comment on this matter? You have 3 minutes.
On this matter, I've been in meetings with the Street Artists Committee, with the Full Arts Commission, where these issues have come up over and over again, which are record keeping, which are how is money spent. And the Clark brothers over many years have done their due diligence of coming before them in a very rational way and asking for information. Why is this fee increase happening? Can we see an accounting? Can we understand where our money is going? And they're told, the way I was, we're going to get it to you, but nothing ever comes. And I think they're going about it in the proper way of going through these kind of channels rather than being out in the street and ranting the way a lot of people do. I don't have a street artist permit simply because it is not transparent at all. You have no idea what's going on over there. Things happen. You get accused. I get accused of stalking Howard Lazar. Only by running a public record search do I know that there's a TRO out for me.
Point of order, can you please stay on the topic?
On topic, which is the time billing is a record-keeping issue that has been a problem for so many years. There is no record keeping within the Arts Commission. And my feeling, though I haven't personally spoken to them about it, is they're asking the city attorney's office for their record keeping because they're believing or thinking that something is going to be forthcoming from them because it hasn't come from the Arts Commission. I know they've asked for so long, over so long a period of time. And the response that they got is a similar response that I got in other ways, much more damaging. But I would believe that if there are documents of any kind that speak to $15,000 somewhere being spent, that they should be produced.
Thank you. Is there any more public comment in support of Member Nee?
I should have brought this motion before public comment, but I will bring it now. I move to find the city attorney's office specifically Mr. Song, in violation of Ordinance Section 67.21E, for departing this meeting before the hearing in which he was a respondent was concluded. His social obligations, to me, are irrelevant. As a matter of fact, he said into the microphone that he would be in trouble. He was supposed to leave here by 7:45. Well,
Yeah, I think he meant 6:55.
well, we can't assume what he meant. He said 7:45. He left long before that. And to me, he's getting a six-figure salary. He can bloody well meet his obligations, as far as I'm concerned.
Second.
For him to depart like that before this hearing was concluded, I think shows us disrespect.
So there's a motion on the floor. It's been moved and seconded. So we already took public comment. I'm going to ask for a roll call vote on this motion. Can you read it? Can you read it
I think we
back?
should actually take public comment again, just because we have not, there's been a motion on the floor, and the public hasn't had a chance to weigh in about it before we take the vote. All right. I know.
What was your motion?
Yeah, brief public comment.
What was your motion, 67.21E?
That's correct.
Okay. If we can make brief comments, then I'll allow it, no more than 2 minutes.
I'll be brief. I support the motion. I think it's outrageous that he walked out of this meeting. How are we going to get answers to questions, that may be brought up in the course of discussions when all of a sudden you turn around and he's gone? So, I think this is the second time we've had a city official representing the Arts Commission and the city attorney walk out on these meetings. And I just, support the fact that something's got to be done, because otherwise, in the process of talking, you may have some questions like, you mean there isn't one document out of those 73 meetings that the city attorney has over at the city attorney's office? There might be questions like, well, those 3 letters that you sent out had nothing to do with the request by Mr. Clark. You mean you don't have any documents? These are questions that we can't ask because he walked out. So I support the motion.
I support the motion for the following reasons. I think that if $15,000 has been billed, there's got to be some accounting somewhere as to how this money was spent, on what, and what time frame. I support it because I know they've gone through other channels to try and get this information, and it hasn't been forthcoming. I support it also from personal experience, because I have been up in the Arts Commission offices either waiting to speak to someone or waiting to try to pay a permit when nobody's been around. And I've overheard Howard Lazar in conversations.
Ma'am, once again, this is off topic. So if you could stick to...
I'm quoting your former chair, Hope Johnson, in the San Francisco Weekly, who says that most of the conversations between the Arts Commission and the City Attorney's Office are spent in trying to figure out how not to produce documents. And I have personally heard those kind of conversations. So I support this motion.
Thank you. Is there any more public comment? If not, the public's comments closed. Discussion?
I would support the motion if Mr. Song had blown off the meeting entirely, had left at the beginning, if we had not had any opportunity to ask questions. I think we asked all the substantive questions, including where are the documents, did they keep anything, all of that. So in this case, I don't think that finding a 21E violation against Mr. Song.
I strongly disagree with that. Mr. Song, who's a city employee, knows that these meetings run until quite late. To leave at 6:47 p.m. is a sign of disrespect, pure and simple.
It's fine. I'm just stating my view.
And I was going to say, generally, I'm kind of torn both ways. I mean, did Mr. Song ask for
To be moved up?
He did not ask him to be moved up, but he did mention that he needed to leave.
Again, it's still 6:45. I mean,
Just saying what he said. And let's kind of remember what's before us, what the issue is. We can stick to that and can all make our own vote count the way you want it to. So at this time, I'd like to ask for a roll call vote.
On the motion to find Jack Song from the City Attorney's Office in violation of 67.21E, Member Nee?
Aye.
Nee, aye. Member Pilpil?
No.
Pilpil, no. Member Sims?
Pass. Pass.
Come back to it.
Member Highland?
aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
No.
Fisher, no. Chair Grant?
No?
Grant, no. Member Sims?
No.
Sims, no. We have a vote of 3 to 4.
So it didn't pass.
Motion does not pass.
Great. At this time, thank you.
Could I get my time billing sheet?
Sure.
Yes.
Can you pass that back? On the bottom.
We're not even charging you for it.
I pay a lot for this.
Yes.
Yeah.
Too much. Thank you for your time.
Thank you.
Making clear that on the substance, we took no action, the matter is concluded.
Matters concluded. Mr. Clerk, Mr. Administrator, can you read the next item on the agenda, please?
Item number 9, complaint filed by Michael Petrellis against the Office of the District Attorney for allegedly violating Sunshine Ordinance Section 67.29-6, failing to disclose statement regarding financial interest with the cities from donors.
So I don't believe I see I can't see the complainant. And the respondent is here. So first matter, let's have a discussion. I'd like to open to Member Nee.
Yeah, I would, my own inclination would be to table this matter and give the complainant a chance to have the matter placed on the agenda for our next meeting. And if he doesn't, then we can put it in indefinite suspension.
Okay. Madam Administrator, I just want to double check. You did not hear from the complainant, right?
Correct.
Okay.
Well, then why wouldn't we dismiss this then? I mean, we didn't hear from him.
Well, because he
didn't
filed
show
the
up.
case. Still, he filed the
But
case.
was he notified properly of the meeting?
I mean, they're here. They've been here all night.
Yes, they were.
Yes, all complaints response were notified properly.
Okay.
And you never heard anything from him? I'm
No.
coming, I'm not coming?
No. So I would like to ask the respondent if you would have an objection to tabling this till the October meeting to give the complainant the opportunity to respond or something happen.
Have the matter re-agendized.
Good evening. I'm Katie Miller from the District Attorney's Office with my colleague Stephanie Stillman.
Hi.
And I actually respectfully would object to having this matter continued for several reasons. As was already stated, we all received notice of tonight's meeting. We've been here the whole time waiting to have the matter heard. But beyond that, I wanted to call your attention to the email exchange that I believe you all have between the Sunshine Ordinance Task Force staff and Mr. Petrellis. The email that went out to him on April 23rd from the staff stated that based on our response, our letter back at that time, that they considered the matter resolved unless he could state a specific reason why there should be a hearing. And his response back was simply that he was not satisfied with our response and he invoked his right to have the hearing without stating any specific reasons. So I would submit that his failure to state any specific reasons combined with not being here tonight is grounds to have this either tabled permanently or dismissed. Thank you. And we can provide more specific information about our response at that time if that would be helpful.
Okay. Thank you very much. Did you have something, Member?
Yeah, I
Vice
actually
Chair?
I have a question. Maybe it's for Mr. Threet. I mean, sorry, I forgot your name already.
Katie Miller.
Ms. Miller stated, hey, we wanted to mediate this, we gave everything, and then Mr. Petrellis came and said, I want a hearing, I want a hearing. He was notified, we all sat here. I agree, as a member of the Sunshine Ordinance, I want people to have their hearings. They should be entitled to their hearing, but they got to show up. God forbid something happened to Mr. Petrellis, but I would like to know about that first. If I find out that, he's very ill, something happened, we'll discuss it, but otherwise, I would say dismiss. Can we do that?
So you had a question, though, for Attorney 3, right? You said you had
Can we dismiss? Yeah, that was my question.
It's within the task force
It's an enigma
discretion.
wrapped up. It was a question in there somewhere.
It's within the task force discretion to vote to dismiss the matter or to continue the matter or to table the matter. You can take a number of actions that way. Dismiss is one of them.
If we dismiss it, can he not just file again if he feels like he wants to bring it in front of us again?
Yes. Yep. It can refile. Member, Member Nate?
Yeah. This task force is on sunshine matters the first and sometimes the last resort for people whose sunshine rights have been violated. And with all due respect to the respondents and the patience they've shown tonight in sitting there for all those long hours, we don't know the reason for the absence of the complainant, and he is not responsible to us. We are responsible to him, and the city is responsible to him. And I would be loath to vote for a dismissal without having heard from the complainant, or at least given him that second chance to appear for us.
Member Sims.
All right. I definitely think it's kind of poor taste that he did not show up and that he failed to appear. And you're right, it's disrespectful to your time as well as our time. I don't think I'm inclined to vote to dismiss just because I'm open to other options, whether it be tabling or continuing. Yeah. Maybe continuing, I think, would be the best resolution at this time. And unfortunately, I know that you don't want to come back here. I would just request, if we do continue, we make sure that he has clear notice, as well as putting this on the first section of the agenda, I think would be, for the next meeting, would be more, should be taken and done by the chair and administrator.
Administrator.
I have a question, actually.
For what it's worth, and I hope that Mr. Petrellis is in good health and wasn't detained for some reason, but he's posted copiously on his blog today, so...
He did what?
He's posted today.
Can I ask a question?
He's active today. So...
Wait,
Member
Pill.
I'm sorry, Vice Chair.
I have a question for Ms. Osbury. So, Ms. Osbury, if we table this...
Post on his blog?
If we table this, so we move it to next, if we move it to next month...
We can continue it to next month.
Continue it to next month, then it pops up automatically. If we dismiss, and then Mr. Petrellis has to refile, does he go all the way to the back of the line again?
Yes, it starts over. He refiles a new number, so it goes to the bottom. Because hearings are heard in chronological order as they're submitted.
Then he should have been here.
Member Pelpel?
Just a thought, and I don't know if it's a good one. What if we just hear the thing on the merits right here and right now in the absence of Mr. Petrellis? I think he's alleged certain facts. We have a response. We can talk about what the office did or didn't do, whether it was good enough, et cetera, et cetera. I'm intrigued by the fact that there's another Katie Miller in addition to the Katie Miller over at PUC. It's nice to meet you.
We regularly get each other's emails, so thank you.
You're doing water engineering in your spare time?
Member Nee?
Never mind.
So we can move along.
I would be reluctant to have this matter heard tonight. We don't have, there may be some facts in addition to what we already have that Mr. Petrellis would like to present. Also, our hearing the facts now would not give, our hearing the case now would not give him a chance to present rebuttal.
Okay.
Didn't say it was the best idea.
Well, in that case, I mean, is there anyone want to make a motion?
Move to continue.
Do I have a second?
Second.
Madam Chair,
Attorney Three?
Does the maker want to move to continue to a specific meeting or the next
Yes,
available meeting?
move to continue to the next meeting, October 2nd.
And can you and say that this would be the first case heard? Sorry.
Well, that would be, that could be a recommendation, but I don't think that the motion needs necessarily to set the order of the agenda. That's
Okay. Okay, so it's been moved and seconded. Is there any public comment?
Second, sorry.
Mr. Oka?
May I make some comment as public? The one thing...
Point of order.
But, I'm sorry, you can't.
Okay.
But is there anyone else here? I can't
No.
see.
Just
Okay.
us.
Okay. Well, in that case, you can't. It's your case. So we need to take, yeah. So I'd like to take a roll call vote.
On the motion to continue to the next meeting of the Sunshine Ordinance Task Force, Member Nee?
Aye.
Nee, aye. Member Pilpil?
No.
Pilpil, no. Member Sims?
Aye.
Sims, aye. Member Highland?
No.
Highland, no. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
No.
Fisher, no. Chair Grant?
No.
Grant, no. We have a vote of 3-4. The motion fails.
Okay. So at this time, there's no action taken, so we'd either need to make a motion to be specific to dismiss, or to table. Those are other two options.
And just close it and done?
Well,
If if there's no motion,
Right, so if we're silent, nothing...
yes. So do I have another motion on the floor?
Well, what would be the result of a tabling motion? What would that do if we
Yeah,
table?
Attorney Three, can you explain that?
Through the chair, you can table the matter to the call of the chair, and the chair then would have the discretion to put it on future agendas.
Madam Chair, I move to table to the call of the chair.
Okay, hold on one second. Let me ask a quick question.
It's continued to the call of the chair. If you table, then it goes away.
Yes, you're correct.
Madam Chair, since there hasn't been a second, I would amend the motion to continue to the call of the chair.
I don't see the sense of it.
Can I see what the difference is of what tabling means?
So how we use tabled basically is concluded, matter is dead. And that's how we use it in the Board of Supervisors. When we table items, also, it's dead. It kills it. And according to Robert's rules, you can bring it back at some point, so it's indefinite, basically.
So then, what if we table it, then does Mr. Betrayus have to then refile a new motion, or because we have something still in our...
Right, since he has still something basically still in the pipeline, if we hear back from him, then he can just...
They're not open.
Sorry, Mr. Oka, can you please respect Ms. Andrea for a second?
I think
Listen
we
to
can
what she's trying to say.
reactivate it.
He can reactivate it, yes.
Yeah.
So he can reactivate it. So we've just tabled it I could table it. Okay.
All right,
Okay.
so my original motion is reinstated. I move to table this matter.
I'd second that.
Great, it's been moved. Oh, you can
On
say
the
that.
motion to table,
Public comment.
Yeah, but he has to read the motion.
Okay.
Yeah, you can read it. And
on the motion to table the item,
Should we have public comment?
yeah, I'm going to give it, but I just wanted to make sure everyone knew what we were making our motion on, and then,
okay.
because she stepped out. Can you read that motion for me, please?
the motion is to table the item.
Great. Did you say just table to the call of the chair?
No, I just said to table, meaning the complainant has the option of asking the chair to re-agendize.
Okay. Great. Is there any public comment? There's no one there. Great. Can we take a
On
roll
that
call vote?
motion, Member Nee?
Aye.
Nee, aye. Member Pilko?
No.
Pilko, no. Member Sims?
Aye.
Sims, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
No.
Fisher, no. Chair Grant?
No.
Grant, no. The motion, the vote is 4-3. The motion fails.
No, because this is procedural, the motion passes.
Passes. Passed. Okay. So,
Yeah, I agree.
yeah.
Yeah. The
So,
motion passes.
yes, the motion passes. Thank you. So that means that, and just to be clear, Attorney Threed, just so we know, we have tabled the motion, and at the complainant can then come back to us or come back to me and ask to have this this matter heard again. But until we hear something, it's concluded for right now. Not concluded, but it's in limbo. It's still on the table.
Indefinite suspension.
Could I ask you, just to be clear, do we have to contact him to?
He has to contact us, right?
in sunshine purgatory. It's in between. Heaven is not hell.
Okay, great.
As I go to synagogue now.
Thank you. Have a good night. Thank you for coming.
Thank you, DA people.
Okay. Let's just go.
And Happy New Year.
Yeah, we're good. So now we're doing procedural things. Can you just read the next item on the agenda, please?
Item number 10, approval of minutes from the March 6, 2013 regular meeting.
I don't know if any, Attorney Threed?
If I could just take a moment, since we're moving on to the minutes, I'll probably be departing the meeting. And I just wanted to let members know that starting in October, you will be advised at the meetings by Celia Lee. I'll continue to be the backup to Ms. Lee, but I won't have the privilege of being here advising you during the meetings. So it's been a pleasure and a privilege, and thank you for allowing me to serve.
Well, it's been our privilege to have you here, and I know on behalf of the whole task force, I want to thank you for all your help and all your knowledge.
Echo that.
Yeah, that you provided to me, and I know the whole entire task force.
And your patience.
And your patience, and we can go on and on and on. But thank you so much.
I think we should take a roll call vote on that. I don't think it's good to listen to right now.
So, hopefully you won't be a stranger.
I also did want to note that since we had an item that we're working together on, I'm going to continue working with you on that so that I don't have to explain to Ms. Lee, to come in the middle of that, but continue to just contact me about that. Okay. Thank you.
Great. Thank you so much. Okay.
Thank you.
Let's continue. So, we're going to approve minutes.
Is a motion to continue in order?
Has anyone looked at, yeah.
I didn't do anything on the minutes.
Okay.
So I would move to continue items 10 through 15.
Second?
It's been moved and seconded. Is there any public comment? No one's here. If not, I believe this motion, I can say, is passed without objection. And let's go to the next item on the agenda.
Item number 16, report, Compliance and Amendment Committee meeting of August 20th, 2013.
Member Nee, you were at that meeting. I know Member Washburn is out, so we can either continue that, or if you could update us on what occurred at that meeting briefly.
Well, basically, what occurred at that meeting has already been revisited tonight. Those were items 12056, and 12059 and 12058, I think, was from a previous meeting. But those three items, what you see is what you got.
Okay, thank you. Can you read the next item on the agenda?
Item number 17, Administrator's
Oh, we
Report.
skipped yours. Public comment? Okay, public comment? Okay, no one's here, so.
There's somebody here.
Well, there is one
That's my
person.
mom.
There is one person in the public section.
Ms. Grant, do you have any comments, public comment?
Mom? Hi, Mom. Any private comment?
Yes, she has private comments. Item number, can you read the next item on the agenda?
Item 17, Administrator's Report.
Okay.
Hello. You have the administrative report before you. If you need me to read over it, go over it, I can. If not,
And Victor doesn't know it off by
No, we
heart?
can read it.
Yeah. No.
Can you read the next item on the agenda, please?
Item 18,
Oh, wait, did you have a question?
Can I be clear that Paula Detesh has like 5 deviations and the respondent provided a response, the complaint did not respond, and it was closed? Is that correct?
that is accurate. I've let Paula know. So she said she will most likely reopen or refile the complaints. But this is correct.
Okay. At this time, can we read the next item on the agenda?
Item number 18, announcements, comments, questions, and future agenda items.
Member Nee.
Hi, I have a couple of things. First of all, as I have mentioned before, the final couple of weeks of this year, I will be traveling, and that means that if I am to remain on the compliance amendments or any other committee, I will be gone from the next committee meeting. So the chair, in assigning committees for the next year, might want to take that under consideration, at least in kind of a stopgap way.
Okay.
The other thing...
So you'll be gone, say that again, I'm sorry.
I will be gone for 2 weeks, starting September 13th.
Okay.
And so... September 13th.
September, next week, right?
Is that no,
Yeah.
for 2 weeks, starting September 13th.
But then you'll be here October,
And I
November.
will be here October, but I will miss committee meetings in September.
Okay.
So that may affect the ability of the committee or committees to muster a quorum. So the chair might wish to consider temporary appointments to one or more committees that she envisions my serving on. The other item that I have is, as you know, we have vacancies in seats 1 and 4. Seat 1 is the holder is nominated by the Society of Professional Journalists, seat 4 by New America Media. Both of those organizations have submitted nominations for those seats. Those nominations are on file along with the applications. So I would encourage the chair, I don't think this requires a motion on our part, I would encourage the chair to send a letter to Board President David Chu, urging that this matter be moved forward through the appropriate committees, which would be the Rules Committee, because obviously these 2 vacancies affect our ability to muster a quorum, and they also restrict our flexibility in committee appointments.
Okay. And I believe I did speak with the head of the Rules Committee, and they were bringing that up with these new submissions, because they just came back for their meeting this month. I don't know exactly when, but they were going to talk about that. We did bring that, so we'll follow up with that.
Great. Thank you.
Member seat 11, Member Oka, is there anyone who has what's the status from the Rules Committee? Do you know?
I don't know anything about that. It's all about the submissions because we don't have anything to do with who gets on there. But I did speak with them about that, so we'll see whose submissions. And Member Pilpul, want to say something?
Yeah, several quick things. Education Outreach and Training is going to meet Monday, September 16th, 3 o'clock in this room. That's the current plan. My birthday is tomorrow. I don't know how I managed to...
Happy birthday. Is that real?
Yeah. I don't know how I
happy
managed-
birthday.
I don't know what I've done for the last... Yeah. And Happy New Year to the Jews who might...
Okay. If there are no more comments or questions or any future agenda items, definitely email me or email our administrator. Like to get a motion to adjourn this meeting?
So moved.
Thank you. It has been moved and seconded. Is there any public comment?
Without objection.
Great. I would like to move this without objection. And I will see you guys in October or sooner. Thank you very much. Thank you very much.